other matter now taken up, not taken up. It is Delhi in the list because now entry model has not been extended. And
No, interim order had not been extended earlier.
the same-
We only clarified it.
that means they are taking now, if they are not taking any action, because why not have clarified on last Monday? I submitted that. But I have a privacy case and it might not be perfect.
We will-
I can do this.
We will try. In fact, today
Yes, I
afternoon
know.
we have a long matter.
Yes, man, I know that is why I am making this.
So
Tomorrow is the,
tomorrow will, and tomorrow is the only date.
yes, only for that
Tomorrow
interim
we
model,
can
I'll,
try.
in my, I fail man, I want. I mean, the extensible.
If it is not taken up today, then we will try to
Tomorrow.
take up
Tomorrow I'll
tomorrow.
make a mention, Madam, I'm.
No, no, you make a mention today itself. Say at, just remind us so that that may be listed at appropriate.
A particular time.
Your lordship.
My beg pardon.
I have taken content of other side. Lord, I have got problem in that. Lord, so I feel that it come after.
You have problem in the matter or you have some problem with
I have
yourself?
problem with the council, Lord. Mr.
All right.
Bikram Senapati, he has gone outside the state.
All
That is why the beef is with him.
So there is no all right. Adjournment matters, don't make a mention, we will grant it.
Your lordship, I made a mention with your lordships. Your lordship is kind enough to permit me to mention it today. Item number 62, the last matter, that is WPC 24745, is a fresh matter. They have not passed any interim order in that, unlike the other matters. The 168.
All right.
168.
All right, we'll-
Kindly pardon me, the last matter, WPC 24745. Similar orders which your lordship have passed.
Take it.
Beg pardon, my lord. Beg-
My lordship, the same batch, my lord.
First matter is already tagged for interim order.
Beg,
Mine
beg
is the
pardon.
last matter. Mine is the last matter. Much obliged.
My lord, beg pardon, my lord. My lord, on Saturday, your lordship reserved that matter where I was, I am filing the date sheet and note of submission.
80. But may be given to
Item 13, sub-item 13 permitted to withdraw.
My lord, this is a fresh matter, my lord.
Give your,
Last order. Sub item. Which,
Item 13.
My lord, this is a fresh matter. Interveners before the honorable single judge were not given opportunity of hearing, my lord, for which this writ appeal has been filed.
all right, writ appeals are not that urgent.
But in the meantime, the honorable single judge, without hearing, my lord, he had given the direction to demolish the community center, my lord. That is the problem, my lord.
Not now.
Your item 78, man. Your lordship directed to file counter affidavit to the chief secretary in that mining matter, my lord. And that the office of chief secretary requested him to grant some time so that they will call a meeting of the three departments and will get.
Oh, yes. So
My,
what do you want?
my senior is appearing and I have already informed my lord senior. So kindly take up this matter on 20.
Ask your junior to make a mention in the matter.
I may be permitted to make a mention, your lordship. WPC number 25273 of 20.
Give your slip, please.
Lordship, this is a very urgent matter because the technical bid of the petitioner has been rejected on an unreasoned order.
had you given memo earlier?
No, your lordship.
Okay.
This is the first memo.
Give
Your
your-
lordship.
give your slip.
You've written everything in the memo.
Yes, sir.
Item 50, that matter and it was coming regularly till the 2 PM list. Item 58,
What is that matter?
That's the additional performance security matter for which the
Additional.
performance security matter. And I've taken consent from my learned senior for the railway. The lordship pleases to take up tomorrow at.
Difficult. How many matters we can take up tomorrow?
Maybe make it.
We will try. Can't,
It was
who
regular-
is for the other side?
Well, this union,
Tomorrow we will take up only urgent matter.
this project is being. I'll.
Tomorrow, some cases have been mentioned, we will take up only urgent matter.
Can't you guys wait till after vacation? Can wait.
Then it's all right. Otherwise, we would have taken up your matter tomorrow itself, and therefore we are observing that tomorrow we will take up
No,
only
my lord,
urgent matters.
I understand.
So all other matters may be adjourned because we don't have,
Yes. You can fix the date for him after.
Don't. 22 years.
23rd.
23rd at 2 p.m. with the lordship, please. Yes.
Fresh read.
Otherwise it is not.
That day you make a mention.
Lordship.
make a mention. When the matter is listed, make a mention.
Obligation. And interim order is that. That's.
May I permitted to mention, may I permitted to mention, my lordship, on item number 42, your lordships. This is a construction of bar association of Chandigarh, my lord. 12th October, your lordship, one disqualified bidder came to before lordships. Only your lordship please to direct to take instructions. But the state has already filed counter affidavit, justified the disqualification, my lord. Your pendency of the writ application, it has not been finalized. I filed a miscase, my lord. Any other, I filed a IA for
Pendency of the writ application.
application. They are not proceeding the tender, my lord. There is no interim order. So I file a IA, my lord. It has not come, my lord. Any convenient date,
Why
your
should
lordship.
you file IA then?
My lord, I am also L1 bidder, my lord.
Then why should you file IA? Who is for the estate in that case?
State, my learned in Mr. PP Mahan.
Yes, why are you not proceeding?
Only due to pendency, my lord. Otherwise, no difficulty.
So many cases are pending, then the state will not do anything.
No, in fact, my lord, in some of the matters, my lord.
List,
Item 42, my lord.
My IA also not come.
Who is for the petition?
The IA yesterday.
Then you will have to inform him.
I
first.
already informed you. I'll again oblige.
I may be permitted to mention a fresh writ appeal admission matter. A fresh writ appeal admission matter, order challenging the order judgment of learned single judge.
Writ appeals are not that, make a mention after the holidays. Because we don't have time. Tomorrow we shall take up only very urgent matters. A day after we don't have time at all. So make a mention after holidays, we will see.
Fresh matter, my lord, after the vacation.
After vacation,
My lord.
make a mention after vacation, not give you slip now.
Had you given the
Fresh
mention?
admission, my lord, after vacation.
Make a mention after holidays. Yes, give it.
Matters under the heading for orders. 45.
My lord, I'm appearing in this case. Here, my lord, on the last occasion, Honorable Supreme Court has not taken up this matter and it has been posted to 12th November, my lord.
Lordship's order dated 25/7.
Eight weeks. Okay. 8 weeks. 8 weeks. Let's have 8 weeks. 12, 13.
Item number 26.
Restoration. Where is Mr. Mankit?
Item 26.
25.
25 is the rest. 25 is we adjourned. Adjourned, that was the first order.
Who is in 26?
26 he has not come. So restoration matches he has not come, but we can.
Not coming.
That is not there. Or defect. This none appears for the petitioner when the matter is called. This is the case on 4/11/2024. In the meanwhile, defects pointed out by the stamp reporter will be removed.
Item 27.
So on the last occasion, my lord, the hearing was concluded. So
Come after holidays, not concluded.
The hearing was on the question of internet.
Yes.
But fixing any date, my lord?
After holidays. soon
After
after.
holidays. Obliged.
What is the second? 23rd.
23rd.
23rd. Okay, or 23rd? 30, you have not.
Item 28.
In this case, notice has been issued on the question of limitation.
appeared, my lord.
105 days delay. We are condoning the delay.
All right, clear. I heard Mr. MP Pundia, Leonard Counsel, Leonard Additional Government Advocate, and Mr. Lakshman Pradhan, Leonard Counsel will appear for the. Considering the period of delay and the reasons stated in the IA, we are satisfied that it is a fixed case for following the delay and filing the recovery. Full stop. The delay is followed and the IA is accordingly allowed. Have you received a copy of the writ appeal?
Yes.
Is any other matter connected or it is?
No, ma'am,
quite
it's-
separate? List the case on list the case on 4/11/2024 for fresh admission. Of the writ appeal has already been served on the Learned Council for the respondents. And I will have a list on that.
Item note 29.
None appears for the petitioner for the appellant when the matter is called. In order to give another chance to the Learned Council, is the case on 4/11/2024.
Item 30.
Well, I have filed an objection to their delay condemnation petition.
What is the delay?
Yes, delay, my lord. My lord.
Maybe.
So, I have annexed one small order of the Honorable Apex Court. That is the plea, the very pedantic plea that we have consulted AGA and obtained some new document, which is not the single judge. So this is my objection that this on ground of delay should be.
So what is the issue involved?
Issue regarding that fourth peon, regularization from the date of his appointment. On document we have annexed to this writ appeal, his matriculation certificate is claiming the date of appointment. As on the date of his appointment, he was 16 years. He was 16 years.
Minor. 16 years old?
As on the date of his appointment.
Okay.
So he cannot even get his appointment at the age of your lordship knows minimum age is 18 years. His very initial appointment is illegal. And that judgment is also contrary to the later decision of this Honorable Apex Court related to this issue. Your lordship may impose some cost on condonation of delay, and I will submit on merits.
How much?
Your lordship, I will not, because this is a fit case, your lordship should entertain this.
The private school, my lord. I don't
Even
know
in
that
private
yet.
school, we can
I
you
have
enter
not
in the
received
16th?
the read Pitson copy.
Yes, I am.
Sheet of it.
Give.
But whatever my learned senior will say, it's a private school, and it is a post of class 4, pure, my lord. When a new school established, he has been appointed as a peon there in, maybe I
You
don't
receive
know.
receive a copy of the writ appeal
My lord.
and we will see.
Yes.
Because if there is some question of law is involved that requires determination.
That is not before the learned honorable single judge.
Right. Then they should have sought review of the order.
Yes. That's the point.
So how much?
10,000, my lord, Pujai.
Why 10,000?
My lord,
Why not 20?
my lord, he is the respondent. He's agreed with 10,000.
Agreement?
I am up.
Benevolent.
Not 10,000.
That's what they can pay. Otherwise,
10,000, madam, we reject your submission. 20,000.
20,000.
my lord obliged.
20,000 responded.
All right. We may confirm.
You've served a copy of the appeal memo?
Yeah. He has the copy of the
So you
appeal.
pay within 2 weeks?
Yes, madam. Payment within 2 weeks, copy by tomorrow.
This for fresh.
It will be paid to council or to the
No.
Respondent.
Council will not take.
Ultimately,
Council
they get
did not. Council voted only 10,000.
based on 411.
Well, let's.
Item 31.
You remember 200 some days delay. madam.
267 days.
267 days delay.
Yes.
My lord, the petitioner is a class D, class 4 employee, group D employee, awaiting for regulation of service since last 15 years. As per the settled position of law, after continuing in a post of contractual post for a period of 6 years, he is entitled to get regularized.
This case
And
will be covered by mail.
below
Which
two
law?
courts, the single court, they have decided that since he is continuing in a contractual post since last 15 years, he is entitled to be get regularized. Here is a WPC writ petition, writ appeal has been filed without annexing the vital documents which has got BOR.
Vital document. Writ appeal, though, no document is required.
I mean, in the original application, in the court below, the appointment order and the sanction order, the post sanction order is available. So as per the sanction order of the government, he has been appointed and he is continuing in the post of the group D post since last 15.
So we may dismiss the appeal. But delay we are condoning. $10,000 cost.
Delays condoned subject to
Not on you, Mr. Counsel.
subject to the state paying 10,000 to the respondent. Okay. Same order within 2 weeks. Can you do it within 2 weeks?
Yes, every cost we are paying.
And you are referring to what?
My lord's judgment that regarding regulation that I will submit that this is clearly covered by my lord's judgment.
On what point?
On that regulation, first basic point your lordship has decided he must have continued against a sanctioned post.
And what is the meaning of regularization?
He'll get a regular scale of pay.
Yes. He may get regular scale of pay. He may continue. But he shall not be absorbed. There is difference between regularization and
He has been posted against a sanction post.
I will have to see.
Item number 32.
Please, my lords, on last occasion, I have directions to condone the delay. Despite of the corona period, it's coming 4 years, some months. The petition.
it was dismissed in 2018. 13/12/2018, my lord. That time corona is not there. It was dismissed 2008.
The writ petition was dismissed
Last occasion,
only with the
filed
cause
a IA for deletion of the name OP number 2, state government they have wrongly implemented as a public.
Submit then, yes?
the writ petition was dismissed only with the reason of non-appearance of the previous council.
That is the reason for dismissal. For
Yes.
That is the reason for dismissal.
Yes.
Reason,
Yes, my lord.
Yes.
When the petitioners, there are two petitioners. One is the mother and other one is her son. The matter is all about appointment on compassionate ground. Senior accountant in accounts office of central
That
government.
is all right. What's the explanation for not filing the restoration within?
My lord, my lord.
Yes.
My lords, when the petitioner approached the council did not inform him. After informing him, he approached to respected Ganesh Rath. With the due time, he passed away from.
But I think the council who has filed this petition is the council who was appearing for the petitioner.
Pardon, my lord?
Council who has filed the CMPL is the council who was appearing for the petitioner.
No, my lord. I have filed the CMP for the restoration.
Restore the
My lord.
writ petition,
My lords.
then what will happen? The writ petition was filed when?
2008.
2008. So in 2024, and when did the person die? The employee, government employee.
Death of the person who in place of whom you're seeking for
2005.
2005.
2006, precise.
18 years after his death, we shall decide on compassionate appointment. What's the purpose? Cost.
My lords, is the necessity and the
No.
writ petition was lying in table for.
So many years. Huh.
Urgent application has been filed for restoration of WPC number so and so, which to this default because of default by an order dated so and so because of non-representation. Was stopped on behalf of the petitioner. Was stopped. Present restoration as application has been filed nearly 6 years.
Yes, my lord.
6 years after dismissal of the writ petition, when counsel appearing on behalf of the petitioner has attempted to touch this court on the point of delay in approaching this court by filing the present restoration application. From the explanation so put forth does not inspire confidence. So, an application has been filed for condonation of delay, which is unnecessary in view of the division being decision of this court in case of 1992 as the rules of the High Court do not prescribe any time limit for filing an application for restoration of a writ petition under Article 2 Constitution. Comma in case it is dismissed for default. Stop. CMPU accordingly dismissed. Yes.
Thank you.
You are
It will be
Mr.
noted.
Satyajit Das.
Village.
List item number 1.
Please votes. Right, here is a case, I came before your lordship earlier, challenging the termination and allow me some time, your lordship. Your lordship direct to file a my such application is pending OP number 1. Lordship direct to dispose of the same, my lord. They have rejected, my lord. Against that, I came before lordship, and your lordship please to direct in the current matter that this is, if the petitioner has undertaken before lordship affidavit, I will complete within 6 months and will not claim escalation. The purpose of the to execute the, it is a road work, to execute the road. And my lord, after that, my lord, I came to know that this proceeding which was on the basis of proceeding which my work was terminated, in the said proceeding, they impose a liquidated damages as well as the penalty, my lord, which is contrary to each other, my lord. Once to liquidated damages, you have to I have to pay, then you have to grant extension for delay completion. So this reason I file one IA which is also listed, my lord, for amendment, and second IA, my lord, for amendment, my lord, for the same work. They invited a fresh tender for a period of 8 months to execute the work, the same work for a period of 9 months on the higher value. Where the petitioner claiming that he will complete within 6 months and within a period of 6 months and in a lesser value, my lord. And in the meantime, tender is still yet not finalized. No work order has been issued because as per today's instruction, my lord, the concerned engineer tender inviting authority, so in some my lord, DA case, my lord, he has been taken into custody. So till date, it has not been finalized.
What order do you want from us?
My lord, the two things, my lord, I am challenging the order passed by the the authority, there where they have imposed penalty and liquidated. One part. Second part, they have.
What second part?
Second part, my lord, the towards extension, my lord.
Extension on what ground?
But my lord, the extension, my lord, there is a proviso under clause 27 of the agreement for extension. Because I want to complete the work because there is a fault, I could not complete it.
It does not have any arbitration clause.
No, my lord, this PMGSY scheme, there is no arbitration clause.
So because there is no arbitration clause, therefore the High Court is required to entertain.
My lord, your lordship is regarding the contractual, your lordship, we are also, my lord, praying before when this coming to the order, we are claiming unreasonable arbitrariness, your lordship, we are claiming.
You can file a suit.
My lord, my humble submission, your lordship, can you see the imposition of penalty and liquidated damages?
That we will examine.
Your lordship, that part amendment, one.
We will see what is the.
Your lordship, that
No, what is the order? What was your original prayer?
Your lordship, this annexure 1, your lordship, page 23, my lord.
Oh, you had earlier come and
Your lordship,
so you are challenging the order, rejecting your.
Lord, paragraph 1 of the order may permitted to place, my lord. Whereas the petitioner so filed WPC number challenging the termination of contract by letter number 1507 dated 20th February 2024 under clause 52 A, B, C, F, H and K with levy penalty at the rate of 20% of value leftover work for the package number OR 02492 PMGH, basing on the approval of chief engineer letter dated 8349 dated 23rd. Lord, that's one to part 1. This was done by behind back.
No, let us see.
Then, Lord, your lordship.
This order, this is the order which you are challenging. Annexure
1, your lordship.
Annexure 1 page. What is wrong in it?
Lord, your lordship kindly have the paragraph 25, lordship, page 25, lordship, last paragraph. This order was passed firstly, my lord, without any hearing to me, and the incorrect fact, your lordship, the principle is passed without any
requirement for hearing.
Not requirement, because since it is related to, my lord, the penal action.
All right. Let us see what is wrong.
Page 25, lordship, lordship, last paragraph. Further, I've said that my 12th line of the, my lord. Further, the regarding fifth array bill quality control register was not available along with the bill. Hence, payment of the fifth array bill could not be made. Besides, before getting the funds, as per requisition, the termination proposal was submitted by the government, which was subsequently approved. Lord, next part, your lords. The superintending engineer Baleswar further explained that the deputy commissioner City and GST Bhadrak had issued a notice modified from GST DRC 13 to the RW Division Baleswar, intimating that an amount
Very
of
difficult, we will not go into such.
that's wrong, my lord, because there is if there is a GST demand, my lord, I prefer to appeal, my lord. Because of that reason, the reason is wrong, your lordship. Your lordship kindly see, on the account of paying interest was against Lakshmindar Padi and direct to pay summit for the upon money became due being fee held. Thus he defaulted payment of tax to the government, my lord. The reason, your lordship, I annex a statutory appeal, my lord, under the GST Act, my lord.
All right, do that. But the fact, you keep on fighting litigation. But the fact is, you, when you were required to complete 1/8 of the work, you could do only 1.61%.
21%.
To 1.61%, see first paragraph.
That means you have earlier been granted the extension.
Yes, my lord.
So under that extension, you completed 21%.
No, can't work.
That's that's related to part number 1, my lord, extension, my lord. Regarding, my lord, liquidated damage, both, my lord, 20% penalty, my lord. Why higher amount I have to, my lord, give opportunity?
One litigation there, one litigation here.
There is no litigation, my lord, except this one, my lord. And my lord, my humble submission, your lordships, my lord, in a contractual, even if I defaulted, the purpose of the subject to lordship and consideration, the object of the tender to do some work, my lord.
It's very easy. Every work should be given to you.
What I'm saying,
The object is that so many development projects are going on, and you are ready to execute all the projects with a lesser price. So everything should be given to you.
My humble submission, they want 9 months. And they want 9 months to be tender, which is not yet from the date of dispute is not final.
What they want, you can't control them.
No, Milord, I am only.
They are free to do.
Milord, only humble saying, Milord, this since this is a severe civil consequence against me, Milord.
It should be.
Milord, so Milord, I humble pray, Milord, I will complete, Milord, on reasonable basis within a 6 months by deploying man machine.
No question. If they give you, it's a different matter. Court will not direct.
Your lordship, regarding penalty, your lordship may kept open, that will approach appropriate forum.
As you want.
That observation.
Yes.
Well,
the petitioner in the present writ application has put to challenge an order dated 18/4/24 passed by
opposite part number 1. OP number 1, lordship. Second.
Is OP number 1?
Principal Secretary to Government.
Passed by the opposite party number 1, whereby the petitioner's representation dated 4/3/2024 has been rejected, mainly on the ground that the delay in execution of work which was awarded to it was attributable to the agency itself, and the agency could not, and the petitioner could not achieve the satisfactory progress due to his lapses. Stop. When counsel appearing, the petitioner has attempted to convince this court that before, this is not the penalty.
This is not related to penalty.
Stop.
But para 1 they quoted me. Penalty.
Next, it is apparent that the petitioner had earlier approached this court by filing a writ petition registered as WPC number of 2024, questioning termination of his contract.
Imposition of 20% penalty of challenge here. So that was imposed when the contract was terminated. Liquidated damages, that had not been imposed.
20% penalty, did they do prayer? Basically, the two earlier and present writ petition related to, my lord, to grant some time to complete the work.
Also,
Basic-
order or termination and payment.
termination and penalty.
Yes.
Both. So both has been rejected.
But the court has directed to my lord, take a decision and remit it to the authority, my lord.
So they have rejected.
They have rejected your.
So, my lord, the penalty, my lord, yes, your lordship, but the penalty part, my lord, the has not been, my lord, addressed the issue because the purpose of the extension applications. So this since it is pending, the issue of penalty or liquidated damage was not addressed nor reflected in the order.
We will address everything. Don't worry.
Then the
we will address penalty part also.
The penalty part, my lord, my humble submission, your lordships.
Yes, where is the order?
Lord, original order, your lordship. Writ petition order, your lordship.
Seven, my lord, annexed to 12.
That means this court had permitted you to approach as regards extension only. That damages.
No, my lord, what I'm saying, similar. Your lordship, as per the imping order, annexure 1 before lord, a decision 23rd February 2024, which is not previous.
Penalty order was passed against you.
Yes, lordship.
You filed a writ petition.
Yes, lordship.
The writ petition was disposed of with a direction to consider your representation.
Yes, lordship.
In the representation, you must have raised the issue of imposition of penalty. And if you did not raise, then you cannot raise because that opportunity was given to you.
My humble submission, of lordships, the penalty order was the communication of penalty in the termination, the penalty approval, which was on behind back on February 2024, is neither impugned before this honorable court nor, my lord, earlier writ petition nor the present, for which I came before that part regarding approval of penalty for amendment, my lord, which was not communicated. Only penalty approval order was communicated, my lord. The proceeding of imposition penalty was not communicated, my lord. Your lordship, kindly annexure 1, page 23, my lord.
In the earlier writ petition, we had not challenged.
No, that proceeding was not challenged. Which is
just a minute.
Your lordship. Only communication dated 29 February 2020.
What are you saying? Come to the first paragraph of the order.
Yes,
for 2024.
That is the communication, my lord. This is my lord. So, my lord, last line, your lordship. Basing on the chief engineer by letter number 20. This is the proceeding, my lord. 23rd February 2024. I enter prayer also quoted, my lord. I have ordered annexed the order, my lord.
Oh, where is 1507 of 29 to 2004-24?
Order, your lords. Lord, page 117, annexure 12, your lords. On the paragraph 3 of the
council,
your lords.
Annexure 12 is the order passed by this court.
Your lords.
Where is that order? Which is referred in paragraph 8, no, in the order dated 18/4/2024.
29 February 2024.
Yes.
Yes, lords. That is your lordships. The annexure 10, page 114.
Page 114,
your lords.
Annexure 10.
Your lords. Once reference
20% penalty.
Yes, lordship, reference order, my lord.
20% penalty, and lordship can see next page 115. Is representation, my lord.
The once your lordship regarding penalty any fine and made your lordship, then it will be all time to my lord.
Yes. Why are you saying that that was not under challenge?
The approval of your lordship 29 February. Let complete. 23rd February they have your lordship annexure 10 your lordships.
This representation wala annexure 1, my lord.
Council, there was an order passed.
Yes,
you had challenged that. The court granted you time to file representation, or your representation was directed to be disposed of. Now, whether in that representation the penalty component was there or not,
No, that is there, my lord.
then why are you saying that you will seek leave?
Annexure 11, page 115. He has mentioned the penalty at page 116, my lord.
Questioning termination of his contract by letter number 1507 dated 29 to 2024 with levy of penalty at the rate of 20% of the value of leftover work for the package OR-092/PMGSY-Roman 3, based on the approval of Chief Engineer. You said that petition was disposed of with direction to consider his representation with certain observation. Paragraph 4 and 5, order dated paragraph 7/3/2024. Full stop. The petitioner's representation has been rejected by the principal secretary to the government by an order dated 8/4/2024, which is under challenge in the present rate application. Full stop. Next, learned counsel appearing on behalf of the petitioner has submitted that petitioner was not given due opportunity of hearing before the impugned order dated 18/4/2024 was passed. Full stop. He has argued that if granted further time, the petitioner is ready to execute the work within a period of 6 months. Full stop. He has further submitted that for the same work, the opposite parties have floated a fresh tender. Fresh tender, and as per the fresh tender notice, the work is to be executed within 9 months.
9 calendar months.
9
calendar months.
9 calendar months. Full stop. In such view of the matter, he contends that if the opposite parties decide not to proceed with the tender process and allow the petitioner to complete the work, it will be in the public interest also. Full stop. Next, we have carefully perused the impugned order passed by the opposite party number 1. Opposite party number 1 has noted in the impugned order that the stipulated date of commencement and completion of work was 10/2022 and 27/2023 respectively. So stop. However, till payment of latest bill within the stipulated completion period, that is second RA bill on 13/7/2023, the petitioner had executed work worth only 1.61% of the total agreement value. So, the opposite party number 1 has noted that petitioner failed to attain even one of the milestones which were to be achieved during the contract period as per the contract data to the general conditions of contract. So stop. Next. From the representation, it appears, from the order, it appears that the petitioner's representation was due, that the petitioner's representation has been duly addressed on each of the points raised by him. So stop. The impugned order, in our opinion, cannot be said to be unreasonable, to be unreason, requiring the court's interference. Stop. The writ application is accordingly dismissed. The application stands disposed of.
Test submission item number 2.
Which is in item number 2, I'm appearing online and on behalf of the appellant.
Yes.
Lordships, there was earlier the delay application has been considered by this honorable court and a delay of 23 days has already been condoned. So today it is listed for admission.
Yes.
Lordships, I am challenging the order which was passed disengaging my my services. And Lordships, with Lordships, let me take Lordships to page 75, which is the order of disengagement.
Which annexure?
Lordships, this is annexure 8.
Yes.
Yes. So, Lordships, this is an order of 17th August 2023. And may I read out the order, Lordship?
Yes.
As per Lokayukta case, so and so, a preliminary inquiry was conducted by the Deputy Director Inquiry Finance of Lokayukt Odisha regarding complaint alleging that the DUG sanction during year 2021-22 in favor of Shri Purnachandra Maharana has been constructed in the courtyard of the beneficiary in violation of the government guidelines instead of on the agricultural land in the Baseli Hata GP of Nursing.
No, what is the illegality in the order of this court?
Lordships, the illegality.
Let us come to this.
Yes, Lordships then may come to the impugned order, which is at page 149. Lordships, it's a very cryptic order where the court has, yes, the court has in fact not considered the submissions made by the petitioner.
Where is that?
Lordships, the court's reasoning is at para 6 and page 150, which is just. And the court has just gone on the factual matrix of the case. May I read out the factual matrix?
Where is the order?
Lordships, the order is at page
149.
149. And 150, Lordships, the relevant
Please wait, madam. Yes. Yes, ma'am.
The case, Lordships, of the government is that I was a GRS. A GRS is a Gram Rozgar Sevak or Sahayak. And I had, in fact, because it was due to my lapse of geotagging that area, the dug well, which is at a wrong place, I have committed a lapse. And some payments have been released to the beneficiary, which again was a lapse on my part. Lordships, this is in fact, these are all false, wrong submissions because I was in the hierarchy. I have been the lowest in the grade.
Issued. Notices have been issued.
No.
I'm sorry?
No notice.
You are accepting notice.
No,
Yes.
notice was not yet been.
Yes. Issue notice. That's- Yes. You have accepted notice for all?
For all, except respond number 5.
Who is respond number 5?
Yes, Sarpanch.
Sarpanch. Well,
Had you filed a counter affidavit?
In the paper, the honorable singular counter.
Filed.
Yes.
A single bench it has been.
all right. 1 week, 6 weeks. So 1 week you file the requisites. Will come after 6 weeks.
Lordships, I have a request. I have moved an application for stay as well.
Where
Lordships,
is the order? There is no order which requires to be stayed. Let it come after.
Lordships, my only problem, if I may be permitted, Lordships, they have already issued advertisement in the other districts. And I fall in the Cuttack district. So they would be issuing an advertisement for the post of a GRS very
We will
soon
see.
in the Cuttack districts. Then my petition becomes infructuous.
No, they have issued advertisement in your case.
No, not in my case. They have
That
issued
you will have the
advertisement in
liberty.
other districts.
You will have the liberty. If they advertise, you can say you can make an application.
Lordships, if that could be included in the order that in case of
That
any
goes without saying, madam. That goes without saying.
Item number 3.
highly obliged, Lordships.
Made resolution. My lord, the grievance is very limited, my lord. While the gratuity, the honorable singular have been directed to pay 12% interest. Though we have no access for that, they have a family dispute. The daughter came forward and say that gratuity may not be paid.
Item 2.
Item 3, my lord.
Who are you?
I am, my lord, I am Tata.
You are?
I am Tata Power.
Tata Power.
Dispute between the daughter and the second wife, or what?
No.
Then-
Mother, sister, and son.
Which item?
The dispute between the
Please, sir.
daughter and now the daughter has died according to her.
CODL.
I'm filing my
You are filing what?
memo and some documents.
Documents will not see.
My lord,
Documents must be there on record in the writ petition. So why are you filing extra documents? Are they not there on record?
only the application form.
We
and-
cannot see any document which was not there on record.
It is shown in the court below.
Who are you?
I am the respondent number 1 and respondent 2.
Let us see the order.
Order is at page 80.
Page?
Page
Anisha 1.
yes, ma'am. And please. Started from page 16.
Hmm?
It started from page 16 of the retaping.
Page 16.
Yes.
Yes.
1/6.
You are aggrieved by which part?
And with that directing to pay 12% interest while paying gratuity. We say that we have no license because of their having dispute, it could not be disbursed. Rest of the pensionary benefits, everything was paid. Except this gratuity. And so far that compulsory appointment is considered para 10. It was earlier directed by the honorable court considered that there is no scheme and there is appointment only monetary benefits. And again, it was directed to consider the application. And if you will apply for compulsory benefits, we will pay them immediately. That is monetary benefit as per their own scheme.
Already filed.
Wife is suffering from cancer.
My lord, they are telling the petitioner's respondent number 1's husband died in 1/6/2010.
Para 9 and 10, that is the one, at page 20.
My lord, section 7.
Who was Mita Maharana?
She is an outsider. No, not our daughter. Neither born from the wedlock of my husband or my husband's daughter. She is an outsider.
According to her, my lord, in the meantime, she died also.
That
So
that is reflected in the order.
yes, yes. There is no dispute for that. Only your lordship may consider that interest portion.
In 10, we have applied for the gratuity. From 2010 to 2019, they sit silent. Section 3 said the employer shall arrange to pay the amount of gratuity within 30 days from the date it becomes payable.
Where is that 12%? 12%.
Page 19, page 9, 20, para 9, last line. Along with interest at the rate of 12%.
Yes.
I'm showing this letter that they have. I have applied in 2011-2010 along with the legal hair certificate
For what?
for gratuity and pension and all the retired death benefits.
And you had filed the writ petition.
My lord.
Writ petition was filed by you.
My lord.
And who is the other person claiming?
She is outsider.
Who is claiming? Treated as party in the writ proceeding.
My lord.
In the writ proceeding, she was a party.
No, my lord.
No.
No, but they claim that she has died in the meanwhile.
Yes, it is not the practice like this. Due to the dispute, they went for that
Civil
legal
suit.
air certificate. Legal air again, certificate granted with the dispute and they have preferred appeal. In the appeal, the appellate court said, sub-collector says, we have no jurisdiction, you go to the court, civil court, and obtain a succession certificate. In that way, the payment of gratuity is stopped. It is no fault of us.
How can they be?
They have not filed any succession certificate.
See, not 12%.
Yes.
Not,
Yes,
not 12%, but because the amount was there with you.
yes, ma'am.
You
No, I am not objecting. As your lordship pleases, sir.
My lord, kindly peruse this letter. That is their document. They have issued me 3,000.
Was there?
No, my lord.
No suit was filed. Was there any dispute about succession?
No, my lord. I have also filed that affidavit to them.
That legal
That is
air
also in
grant of legal air certificate was no appeal filed by the other lady.
no succession, no notice. That I have also filed an affidavit towards that. That is also in the record.
Record of the writ
You will
petition.
have to stay in the order.
And before them. Before whom?
Before the authority.
Oh, you were asked to approach them. That order also you've been asked to pay 12% and asked to approach. That order is already there. Thereafter, there is an order for regarding appointment that you were asked to approach.
Have you read
2019, they asked for from 2010 to 2019, they sit silent.
Mr. Das,
My lord.
paragraph 9, they say that they will approach you with all the documents in support of the contention that so and so is dead.
Yes.
And along with that, they will also file an affidavit that indemnifying the opposite party in case of opposite party.
May I clarify within 1 or 2 lines? They have applied for legal heir certificate. Legal heir certificate, the name of Mita Maran is not there. She approved. So she approved the appellate
That
authority.
is the problem. And
Yes,
if we are asking
yes.
her, she's saying no appeal, no certificate, no
Yes,
nothing.
yes.
The
Appeal
correct
was
facts are
preferred.
not stated. How will we
Yes,
decide?
appeal was preferred by Mita Maran. And the SDO says, my lord, I'm reading. Now, in view of the above, it is a disputed question of getting the family pension of late Raghunath Maharana. Two parties are claiming.
Matter, the whole difficulty, madam, is that you are not, you are disputing everything.
No, my lord, I'm not.
What no?
You may not admit her right, but the facts you have to tell us. Otherwise, how will we decide? Everything you are saying no.
My
It's all right.
1/6/2010, the petitioner, the respondent's husband died.
Yes.
Then in 2011, 2010, she
Madam,
applied-
there was a lady. According to you, she was an outsider. She may be an outsider, we don't know. But there was a dispute. A succession proceeding was initiated.
No, my lord, no succession proceeding.
Okay, appeal against grant of legal heir certificate, not including her as a legal heir. Was there an appeal? Yes or no?
Yes.
Yes.
There was an appeal and
All right, we will pass order.
I was cancelled. Then again we have applied.
All right, we will see, madam. We will see.
And we have issued the legal heir.
We will pass order.
In the meantime, some amount, undisputed amount may be released.
Release that.
We are ready to accept gratuity, everything is paid.
So
We have
gratuity.
stated.
The gratuity amount you release with the,
My lord, I have
your
no-
main problem is the interest.
Therefore, I'm saying your lordship may dispose of just now, we are ready to pay. Not that I'm disputing not to pay.
In the meanwhile,
Only I'm after interest, nothing else.
the amount of the gratuity amount, the principal amount of gratuity must be paid to the
In the name of respondent number 1.
to respond number one.
The wife.
Wife, my lord.
To respond number one, the court will consider passing appropriate orders on the. All right.
Disposable.
Yes, no, we have kept it to enough, but in the meanwhile, you pay the gratuity amount you release.
Yes, yes.
Interest or whatever.
Principal
it is.
release, we will say,
Yes, it can be treated.
Yes, ma'am. I have no objection.
do it by tomorrow, if possible.
Grant me that today, then
Yes, yes, we'll.
You'll get it.
yes, ma'am. Can it be a free copy, madam? Can it be a free copy? Equal certified copy will be delayed.
Certified copy. You tell me tomorrow in the morning whether you have received the certified copy or not. You file online, you will get it.
All right, all right.
Item number 4.
Yeah. Here the petitioner, the appellant is a peon, 58 years old, not getting granted it. And initially approached the State Education Tribunal in the year 2011. And in the year 2011, there was a direction to the government to consider his case. And in 2013, under Annexure 1, the government rejected the applications. Let's just glance the Annexure 1, page 9. the year 2011, he approached the Education Tribunal and Tribunal rejected the application. The Tribunal directed the government to consider. Lord, she got it that page 9, annexure 1.
Where is the order of the court?
Yes, Minister. That
Where is the order of the
annexure
court?
7. Annexure 7.
You are not challenging this order, you are challenging the order of the court. Let me see the order of the
I am
court.
challenging the order of remand. You know, she kindly see page annexure 7, page 104.
Yes.
Matter was remitted to the.
Only remand matter I have questioned the remand minutes because this litigation is familiar since 2011 and this is the third court tribunal 104.
Dispose of the GI by the end of 2024.
That's right, but that's right. But this is 2024. But in 2020, 2011, I am fighting the litigations. And that too, the issue
2024 order.
Thereafter, the FAO has been.
The very same day delay was condoned and that order was passed.
Limited like and decide again the end of 2024.
And the state filed.
Just a minute, Mr.
What is the meaning of directed appellant number 1 to consider the case of respondent instead of taking final decision on the claim of private respondent number 1? So who is respondent? Who is private respondent?
You were in the first appeal. Who were you?
I am Lobo Kumar Rathod, the petitioner before the Education Tribunals. The government filed the appeal.
You are not heard.
That matter on that day, the delay condoned petition was there, and that was 625 days it was condoned, and that order was passed. But so far that order is concerned, kindly see the order. That is a region order. That GI application was allowed.
Mr. Counsel, whether you were heard.
I was there, Millers. I was heard. On the first day, the limitation petition was there, and that was condemned subject to payment of 4,625 days delay, and that order was passed. The government said that is judgment is applicable. That Harjit Singh Kaur case, that judgment is not applicable in my case. And it also kindly see page 72. That judgment is a very rigid order. Judgment, 15 pages judgment, where the J application was allowed. The Harjit Singh Kaur case, where there was no adjudication, the matter was remanded. Here the adjudication was there. Let's say for that sake I pray. Let's say kindly see page 72. It is very rigid orders. Page 72, the order of the tribunal. Let's say kindly see that is very rigid orders, and that too the counter was filed, the rejoinder was filed, and that was the order, input order was quashed, and direction was there. And by applying the Harjit Singh Kaur case, now they have said that you remand the matters. Because Harjit Singh Kaur case have annexed. There is no counter was filed. In that case, no counter was filed.
Who is on the other side?
The government, Millers.
Yes. Yes, please.
Yes, my lord. The only question here, my lord, Lord Smith, page 104.
Yes.
This writ appeal arises out of an FAO. So, my
It is
lord,
not maintainable.
I am submitting, my lord. In fact, the full bench of this honorable court had decided in one case, writ appeal is not maintainable. But a recent judgment of this honorable court, but in that case, it has been said against FAO, the writ appeal is maintainable. If your lordship will take into account that judgment of the full court, sorry, by larger bench, then this writ appeal is not maintainable.
Let us see.
What is the decision of this court?
My lord, that copy is not by, I can get that, I can give my lords that reference. That is W number 666 of 2023.
This one?
Yes, I think that Justice Sarang is the reason mention that.
Whether full bench has been taken note of. Whether full bench decision has been.
My full bench,
full bench judgment से कौन कौन दिखा था सीधे कौन पर दिख रहा है पूरा what they have stated referring that judgment what is the full bench distance let them say in the para 10 so kind of maintenance question was there para 10
South,
Yes.
page, paragraph 2. From brother.
para 10 the question of maintenance was there and that has been answered.
Wow. 2010 volume 13 SCC 517.
So it's confirmed in that.
Yes, yes, that is written in that order, but where is that? Paragraph 13.
I have given that full.
So where is this order? WA number 143 of 2016, 2016? 2000, yes. WA 143, come to paragraph 18.
Yes, in that they have relied another judgment of this annual WA. So that I will verify that also. Let me see the larger bench judgment I have given that copy.
This is the provision.
24C of the Orissa Education.
49.
There is no other.
This is the only order.
There must be a subsequent order. It was dismissed, but there is no other order.
Give us. This is.
This they were considering it preliminary, so they have entertained and then dismissed. But no, no.
They have entertained.
No, this is a preliminary.
A lot of like. The present appeal, intra-court appeal, has been preferred against an order dated 9/5/2024, passed by a learned single judge of this court in FAO number 119 of 2024. show us that the provision
24C of the
where
Orissa,
you file FA. First appeal.
24C of the Orissa Education Act also.
Education Act.
24C of the Orissa Education Act.
The Secretary, Education Department, Orissa, had filed a first appeal giving rise to FAO number 119 of 2024 under section 24-C of Orissa Education Act 1969. Section 24C of the Act reads thus. Oh, stop. Mr. Khutia Learned AGA, appearing on behalf of the respondent in the present intra-court appeal.
Respondent 1 to 3.
And 1 to 3 in the present intra-court appeal has raised an issue of maintainability of this appeal, relying on a full bench decision of this court in case of Muhammad Saud and others versus Dr. Major Sheikh Mahfouz and others, reported in other bracketed AIR 2009 Odisha 46, which has been affirmed by the Supreme Court in case of Muhammad Saud so and so, reported in 2010 volume 13 SCC 517. So stop. Learned counsel, appearing on behalf of the appellant, has on the other hand relied on a division bench decision of this court in Prasanna Kumar Sahu versus State of Odisha and others, dated date
17/1/2024.
17/1/2024 in WA number 666 of 2023, bracketed Prasanna Kumar Sahu versus State of Others and batch. Paragraph 18 of which reads as under. So stop. Relying on the said decision of the division bench in case of Prasanna Kumar Sahu Supra, learned counsel appearing on behalf of the appellant has submitted that this intra-court appeal passed against filed challenging an order passed by the learned single judge in a first appeal under section 24 bracketed C of the Act is maintainable. This writ appeal was filed against what? This.
Against the FO, that 24, that present appeal. Just
No, no, this 143. No, no. WPC. Of the.
What is the number? Huh?
Okay.
In line on the same decision of the division bench in case of Prasanna Kumar Sahu, the pointed that this interport has been filed challenging an order passed by the United Kingdom, past appeal on a certain or three of the act is done.
Act is untenable. So, it is the division bench of this court in case of Prasanna Kumar Sahu has 18 paragraph 18 put kara, 18 put kara, or 18. It is manifest from paragraph 18 of the division bench order in case of Prasanna Kumar Sahu bracketed supra that the division bench relied on a full coordinate bench, an order of a coordinate bench of this court in WA number 143 of 2016. The division bench observed that since the coordinate bench in WA number 143 of 2016 had entertained an intra-court appeal, there is no reason, intra-court appeal referring to the full bench decision in case of Muhammad Saw bracketed supra, there was no reason why the division bench should take a different view. Also, the orders passed in WA number 143 of 2016 read thus 29/9/2021, 27/9/2022. Stop. In our considered view, the issue as to whether a writ appeal shall lie against an order passed by a single judge, passed by a single bench in a proceeding under section, in an appeal preferred under section 24-E shall lie or not requires consideration by full bench. as the view taken in case of Prasanna Kumar Sahu, bracketed supra, is based only on the fact that a coordinate bench had entertained these arises also.
Now consider these two has to whether a recalculating are live against an order path and saving which will report on
You're a vacation.
6 full bench
By a full bench, since the view taken by division bench of this court in case of Prasanna Kumar Sahu is based only on the orders passed by another division bench of this court in case of so and so noted above, which arose out of the proceedings under Articles 226, 227 of the Constitution of India. So stop. Let it be placed before the Chief Justice for placing the matter before a full bench.
Item number 5.
Item number 5, Lordship, on behalf of London Council, Mr. P.K. Pradhan, can be taken up after vacation. Problem.
Yes.
Item number 6.
Please, Your Lordship. Operative part of the order is at page 60, my lord. Page 60. 60.
Yes.
Upon hearing, should I read it, my lord?
Yes, please.
Upon hearing the learned counsel petitioner, on perusal of record, this court finds that a complaint was made challenging the candidature of the petitioner by one Vishwajit Maharana in WPC number so and so, wherein the territory manager BPCL filed an affidavit stating SCBC certificate is equivalent to OBC certificate. Thus, seeking clarification from the Tahsildar Ersama by BPCL is only a method to delay the matter. The same appears to be unnecessary in the instant case in view of the reply made by BPCL in WPC and so, which was filed challenging the candidature of the petitioner on the self ground. It appears there is no legal impediment to issue the letter of intent. Accordingly, the Lordship has directed to issue the letter of intent in favor of the petitioner. My submission is.
Yes.
At para 5, my lord, I had stated that we are seeking clarification from the Tahsildar regarding the consideration of SCBC certificate and OBC certificate. And I was denied an opportunity to file a reply also. Only at the first instance, this has been disposed of. And the writ petition Your Lordship was referring to is, it has not been adjudicated upon me. It has been withdrawn as want of instruction, my lord. That is
What
at
has been
page.
withdrawn?
That writ petition which Learned Singh Judge has relied upon, my lord. No final order has been passed, my lord. That is at page 54, your lordship can see.
Oh, you are challenging which order?
I am challenging the page 60 order, madam.
Just a minute.
Page 59, it starts, my lord, operative at page 60. The core issue, if your lordship may permit me, I had floated an advertisement for a dealership.
Yes, yes. So, see, learned single judge has held, rather he has concluded.
Yes.
That SC/BC certificate is equivalent to OBC.
Yes, ma'am. But my guideline says OBC central or state. And the selected candidate unfortunately does not fall within the purview of OBC, my lord. And that has been clarified in the letter of the Tahsildar, which is at page.
Are you sure that SC/BC is not OBC?
No, man. At page 80, 65 your lordship.
What is OBC?
Other backward caste.
So
And
every SC/BC is part of OBC.
No, man. That's what the
every SC.
That's what the Tahsildar has clarified, my lord.
Economic factor is there.
Backward class.
Page 65, annexure 8, that's what Tahsildar has clarified.
So
That is other backward class.
Other backward class.
Backward class.
There should not be any difference. See, EBC. EC is part of OBC, Mr. Counsel.
Before that, your lordship may see annexure 8, page 65. That is the only last submission. I am to say that on verification of the caste of Sushant Kumar Mahapatra, son of so-and-so, is of Khandayat caste. The Khandayat caste is does not is not belonging to OBC category, and it is found the Khandayat caste, it belongs to SCBC category as per the list of SCBC classes. This is my last submission. Beyond that, I have nothing to say.
One person, that's it. What will you do?
Tahsildar.
I am not in favor, not in against. I want a judicial finding.
Why? Very good. You want a judicial, you have already. You have already a verdict.
But this annexure stay, it stands against me, my lord.
What?
That this both are separate.
That challenges the order of the observation of this bench, this court. Yes, state.
And my
No, state may not be a party, but regarding
State is
the
not a party.
certificate,
no.
issuance of certificate.
What is this SEBC and OBC?
Yes, I will get clarification from the authorities. So, lordship, I understand.
If SEBC is caste based, then that will be form part of OBC also.
Lordship, I could understand, lordship. OBC will definitely fall under the category SCBC. OBC will fall.
SEBC will fall if it is caste based.
Yes.
So, and if it is only this thing, economical, then
it's different. Yeah, I understand now.
And if that caste does not fall in the list of OBC, then he will not get.
Yes, that clarification I will get from the government also.
Learned counsel appearing on behalf of the appellant is permitted to impede the state of Odisha.
I am serving the government.
Through To whom? To State of Odisha to
Not so, you may say, it's CAS means Revenue and Disaster Management.
Revenue and Disaster Management Secretary, so and so, the Revenue and Disaster Management. First off, let it be done by the registry. Registry. This is for the sole purpose of.
SCBC is part of OBC, but he's giving this.
Yes.
Necessarily part of OBC. That's not below.
No, we don't do that. Depend on. Only for the state of Odisha has been implemented for the sole purpose for this court to consider as to whether SEBC is part of OBC or not. That's all.
Yeah. Or you also may say OBC is part of SCBC because once they say that he belongs to SCBC, once OBC comes under SCBC, automatically petitioner is entitled to get it.
SCBC will come within OBC.
SEBC will come within OBC because OBC is larger.
Larger than the UC. It's caste based. Yes, it's caste based, that is not economic condition based.
No, and caste based also. If SEBC is not caste based, then that will not come under OBC. But if SEBC is caste based, then it will come.
So backward class, which is socially and economically.
Item number 7.
May I please, Mal? Mal, this matter was previously before the Honorable Single Bench, Mal. Then after this matter has been referred to this as the nomenclature change as PIL, Mal. Mal, recently, the government of Odisha has formulated a scheme and advertised, Mal, there's Annexure 1 for the rooftop solar system, Mal, with subsidiary, Mal, with huge subsidiary, that is Bhubaneswar Go Green with affordable rooftop solar system that is coming under the Green City Mission. And specifically, they have limited this project under the Bhubaneswar Municipal Corporation, Mal. The present petitioner is a senior citizen, Mal, and she is residing hardly 50-60 meters away from the municipal jurisdictions, Mal. Now, she has approached, Mal, but her approach has been rejected, Mal. But in other states, in Tamil Nadu and in other states, Mal, this project is totally in the whole of the states, Mal, that I have given, Mal, that is Annexure 5, Mal. In Andhra Pradesh and that is in Telangana, the scheme is totally throughout the state, Mal. But in Odisha, Mal, it is already only they have limited inside the Bhubaneswar Municipal Corporation, Mal.
Any legal right?
Mal.
Any legal right? Any legal right has been violated.
Mal, because they have
Do you have any right?
Well, because they have only confined to Bhubaneswar Municipal Corporation.
Do you know which state you are referring to? Madras? Tamil Nadu?
No, from Odisha, man.
Odisha. No, you are talking of Odisha. You are comparing Odisha with some other state.
But it is a central government project.
Central government. Yeah.
Please, man.
So if your house is 50 kilometers away.
No, 50 meters only, man.
50 meters away. Then there may be houses 100 meters away.
Yes, man.
1 kilometer away.
But it's a twin city, Malad. Kotak and Bhubaneswar, it's a twin city. So it is not far away, Malad. And recently, Malad, I have got an information, Malad. One day before, they have one meeting in the cabinet and they have taken some decisions, Malad. The government council should take instructions, Malad. Just I got the information.
You seek instruction.
This is coming under the Prime Minister, that is free. That is Prime Minister Surya Ghar Muft Bijli Yojana, madam. That is Annexure 3, madam. And this is throughout the India, madam, throughout the nations.
How are you making these submissions? Throughout India, therefore it should be throughout India.
Yes, madam, but they have confined in, Odisha, they have confined in Bhubaneswar Municipal Corporation.
Therefore, according to you, this is Prime Minister's scheme. Therefore, it is for throughout India, and therefore it should be there everywhere.
Yes, ma'am.
Irrespective of the resources which they have.
But it is there, madam, in documents they have mentioned it.
All right, tell us what is your legal right?
There are questions of right to equality, madam, because
Right to
when a
equality.
scheme has been formulated by this.
You can argue anything, Mr. Counsel.
No.
Anything you can argue. Right to equality.
Well, recently, on one day before, madam, they have taken some decisions, madam. So they have to take some instructions.
Yes, do you have any idea?
Sure, it was confined, the subsidy part was confined to city of Bhubaneswar, Your Lordship. That I know. But that is again for the discounts, Your Lordship, to decide how much subsidy they want to give or not.
All right, file your
But the minimum that is to be given by the Prime Minister Surya Ghar, Your Lordship, that is equivalent to all over India. But in Bhubaneswar, the discounts are offering a little more, Your Lordship.
But I am to the discount here. The scheme at Annexure 2, page number 10, that particular scheme says the scheme will be implemented through Odisha, through the Renewable Energy Development Agency and the DISCOM. However, it says Bhubaneswar has been chosen by the Ministry of New and Renewable Energy to be converted into a solar city. So they have floated it for the time being to Bhubaneswar to first convert it. And thereafter, my lord, they will take a call, the Department of Energy. But therefore, when the petitioner approached us, we said we are governed by the scheme. So it is only applicable to the Bhubaneswar under the scheme. Therefore, we are unable to
dismiss it. Requested on behalf of the party, list this matter on. Reopen. Yes, next.
Item 8.
Eight, my lord, matter relates to the notifications issued under 168A of the GST Act. Similar matters are before the lordship.
When are they coming?
Today they are on the board. Item 62, my lord.
52.
62. 62, my lord.
62. All right,
man. I pray these matters may be tagged along with 62 and may pray for similar interim protections that your lordships has granted. I've been pleased to grant in those cases.
Yes, thank you.
In last two items, my lord, I am appearing for the department. My name is not.
No.
First item I am appearing, second two items.
Give it, Mr. Musti. Please put it in a slip.
Yes, madam.
Item 9.
May I please, Your Lordship? Your Lordship, in this petition, the order dated 25/2024 passed by the MD OSPC cum mediator has been challenged, Your Lordship. Your Lordship, the brief fact of the company who was engaged in giving service.
You are challenging which order?
Your Lordship, order wide annexure 8, Your Lordship. It's 79. Your Lordship, the brief fact of the case is.
Mediation, you had argued this matter.
Yes. We had started this matter, Your Lordship, and Your Lordship raised it. Your Lordship, the brief fact of the case is that the petitioner is a company which provides security personnel, Your Lordship. And the petitioner was the L1 company and had executed agreement twice, once in the year 2018 and one in the year 2019. Your Lordship, thereafter, the petitioner company was served with a letter demanding for the amount, for the recovery of amount for the shortages of the beverages in the different depots under the opposite party, Your Lordship. Your Lordship may see the impugned order, Your Lordship, last paragraph, which is page 89, Your Lordship.
Shortage of stock shall be recovered from the manpower.
Yes, Your Lordship. Manpower company, Your Lordship.
And the OBC office fails, right?
And the opposite parties, Your Lordship, have relied on two clauses of the agreement. Your Lordship may kindly turn to page 69, which is the clause 33, Your Lordship. As per this clause, Your Lordship, if any mischievous activities is found from the second party's deployed outsource personnel, and for that reason, if any loss of stock occurred in OSBC, the second party shall bear the financial loss and deposit the amount of loss in OSBC account, Your Lordship. Your Lordship, my submission is that at no point of time, any mischievous activity on the
Your plea was that the nature of dispute resolution through mediation is of arbitration, and therefore the dispute should be decided. He has referred to the provisions of the mediation rules
Yes,
and dealt with the scope of mediation. No.
Your Lordship, there was a mediation clause in the agreement, and as per that agreement, this Honorable Court directed the petitioner to approach the mediator, and the MD is the mediator, Your Lordship.
So, madam, so this mediator is under which provision? Mediator is under CPC. Mediator has to do in accordance with the rules framed. So he cannot decide disputes, and he should not have written such a long order. He could have simply said the mediation failed. You could have taken steps. Just see. Come to page 85.
Yes, Your Lordship. Lordship, when initially I was for one depot, I was informed that there was a mischievous activity on part of some of the employees. Then the amount was recovered from those employees, and the loss amount was paid to the opposite parties. However, thereafter there are two more depots that they are alleging. However, they have neither pointed out what mischievous activities have been committed or by whom.
That has not been admitted by you.
No, Your Lordship.
Because there's a reference saying that since you have admitted, nothing is there to be decided, so
Yes, Your Lordship. They are referring to a previous payment that I had made regarding shortages that they had informed to me, and now they are claiming on that account I should be giving another 1 crores and 19 lakhs amount, Your Lordship.
Was it urgent so that you serve a copy of the council?
No, Your Lordship.
Item number 10.
Issue notice.
Obliged, Your Lordship.
My lord, this is nothing matters, my lord.
Yeah. That matter relates to nursing and pharmacy Miller. Last occasion, on last Miller, my respected senior Miller, Mr. Mahanti, has brought to your lordship kind notice in some of the matter. He has got instruction from the department Miller, which can be covered by your lordship order.
But I have given the list.
Item
number 1, my lord. Sub-item 1, that is Divya College of Pharmacy. It is covered with the principal's matter because the pharmacy admission has been extended up to 30th of November. So, my lord, a date can be fixed for personal appearance before the DMT. This in 14th or 15th, any date, my lord will say.
14.
14 or 15. 14.
14, there is no puja or anything.
No puja.
The office is open.
Yes.
Principal. Principal not available.
Given the case number.
The next one, my lord, SJ School of Medical Science, my lord, this is covered by that denial of inspection. That number I have given, that 5 days, 2 days, 2 days and 1 day election, that may be covered up with that.
Covered.
Have the order, Mr. Das?
Yes, Miller.
Order, please keep the order.
Yes.
The next one, C. Jagannath College of Nursing, my lord, also this is covered. Same order.
Which date?
This is regarding.
No. Mr. Das is. The date has to be fixed.
No date has been fixed. No date fixed. In principal matters, we fix a date.
Oh, you will reschedule and inform?
Yes.
All right.
Then the Gayatri College of Nursing, my lord.
Yes.
Here, the petitioner has produced fake certificate.
File a counter affidavit.
And proper, I will file, my lord.
Miller, now the certificate is there, not a fake certificate, Miller. No, whether you had ever submitted any certificate or not.
Yes, my lord.
Yes, Miller. Whether that was fake or not. Yeah, that was not fake, Miller. So let him file counter affidavit. In the meantime, not there. Subject to verification, your lordship.
No, that certificate cannot be relied upon. You have given a fresh one.
Yes, Miller. That is Annexure 5, Miller.
Because fake certificate he has given.
If they consider it's a different matter, but if we reach a conclusion that you had submitted a fake certificate, we will not entertain your application. In no case. Let them file affidavit.
Yes, ma'am.
So once we reach this conclusion that the certificate was fake, and we will direct them not to grant. Miller. But that was not a fake one, Miller. We will decide. It was brought to our notice. We approached the fire department, obtained the certificate, Miller. We know the definition of fake.
Yes,
if we reach that conclusion, then we will restrain them from issuing no objection. All right.
Next one also, my lord, I want to file counter. I have received the copy. I have to file counter.
Counter.
Next one is pharmacy, it can be extended, but time has been extended by the Supreme Court.
Counter.
Yes, my lord.
The Lordship can fix up a date, my lord, because last date is 30th November.
All right.
All counters.
Lordship, sub item 3 of that.
Just a minute.
Your Lordship.
Sub item 3, you are in sub item 3.
Your Lordship.
That is
It can
covered.
be.
Yes, my lord.
Yes, so
Then item number 13, my lord, if my lord will take.
4, 5. So
Five.
the date means R date.
counter.
What is the last date? November?
30th November is for pharmacy.
So these two are pharmacy. 4, 5. 4, 5.
One
Size is pharmacy. Last one is pharmacy.
4 is pharmacy, 5 is pharmacy, 4 is nursing.
Okay.
Yes.
Then my lord, if my lord will take item 13.
11, 11.
11.
So
13.
11, 11. Date.
11.
Next date.
Yes, my lord. 11.
Next item.
Item 13.
Yes, my lord.
इसको चाहिए लगा?
13, call for 13.
Item 13.
My lord. Item 1. Is it is a fair certificate found fake? Counter I have to give in this case.
Yes, but if you find a certificate fake, then you are under obligation to file FIR.
Yes, that's my lord. There is also provision of ours that for 5 years you will debar them for getting NOC. That is there as the notification. I will place it before.
Both of the things.
Yes, my lord. Then the next one is Viju Patnaik Nursing College, my lord. Just copy. I received the copy. I will file counter in this case, my lord. No, my lord, I will file counter.
Yes, let them file counter.
And the nursing council is a party, but they didn't serve the copy to us, sir. Let them serve.
Serve a copy. Yes.
Then, my lord, Shubham College of Nursing. This is denial of inspection, the same order, my lord. 20418. To reschedule.
Yes.
Then Bhimtas, the next one is Bhimtas School of Pharmacy, my lord. The principal is not eligible. If you want to give it, he can be present on before the DMT on 14th with the principal and the documents.
Covered by the Lordship.
As covered by the judgment.
Yes.
Then, my lord,
in that case, my lord, your lordship may permit principal or the chairman, my lord. Principal is now hospitalized. He has some cardiac problem. He is undergoing treatment. Principal or the chairman.
with all necessary documents.
Yes.
Yes, ma'am.
Chairman of what?
Institution. Or vice principal, my lord, we will be there present. Better is vice
What is
principal.
the cardiac problem? What is the cardiac problem? Yeah, has he undergone any surgery?
Yes, madam. He is undergoing treatment, madam. I was informed that he is undergoing treatment.
I am also undergoing treatment. Yes. So, undergoing is a very vague term. And this is statutory requirement. If he does not appear, if he is hospitalized.
Yes, madam.
If today he is hospitalized.
Anybody can submit.
It's on you.
Yes.
Whether you go there or not.
Yes.
Say principal, not chairman.
Because they'll fix a date and time, so that time you can go.
Next one, my lord. Hariyan Nursing College. This is also the fire certificate is not complied with. So I will give a counter in this one.
Counter.
In that case, fire certificate is already there. It is not a fake fire certificate.
All
case,
right,
my lord.
all right. He said
5 series is the fire
let him
certificate.
file counter affidavit.
Yes, my lord.
Subject to verification, it can be disposed of.
The next one is, my lord, copy has not been served on me. The copy is served, I will file a counter to this case.
Who's there for the
13.
petitioner? 24535. Nobody.
No, no, sir.
Nobody.
No.
Anybody appearing? You are there?
And some item 6 and 7.
No.
No.
Restriction number 24535.
So 6 counter will be filed.
Yes, my lord.
7
He has to
serve a
give it to
copy.
me.
In course of the day.
He has to give me copy, I will file the counter.
Serve a copy.
In course of the day, I am applying.
Do it.
Another sub item.
No, your sub item only, your sub items will not be taken up. One by one. Yes.
Two consecutive.
2 consecutive, it's all right.
5 and 6. Both copies.
7 is copy not sought, but it is a covered matter, the denial of inspection, my lord.
Without copy, you know what it is.
No, my lord, because
Checked from the
in
department.
notice,
All
that
right.
notice. Yes, my lord.
So that disposed of.
That can be disposed of because it is by that instruction.
Date.
The next one is, my lord, Netaji College of Nursing. This is for online declaration, the same disposal with the same order. Yes,
Same one.
yes, my lord. The next one is also the same, Jasoda.
Any counsel there?
Your Lordship,
You're there?
Your Lordship.
No. You are, no, the Rupesh, Mr. Kanungo. Is he
Your Lordship, I am appearing on behalf of Mr. Customer.
Region, next one, my lord. The hospital's application was not available at the time, but now he has already submitted the application. We may consider the case. Only hospital affiliation that we will take into consideration if it is there.
Item 13, 10,
Yes, my lord.
11, 12, 13, all. No.
Yes, my lord.
8, 9, 10.
No, 10 only.
10 only, my lord. 11 is covered.
11.
Then 12 is Ava Nursing, that is also, my lord, fake certificate. Copy has not been served on me.
Initially, submitted the application regarding fire service.
Copy has not been served on me.
Sir.
I will file counter. Sri Jagannath is in the morning, he has withdrawn the matter.
Yes.
The 14 is again covered by this inspection, my lord.
Simon, this is a case matter, your lordship can say annexure 11. I was not coming within the instruction. My date is not on the election day or previous 2 days prior or 2 days after. My case. Well, they'll consider. They will consider. Yes, your case is covered by some decision. The annexure 11 is to be questioned because they denied. Then serve a copy on it.
Which copy?
A copy has been given, I think.
Which copy has not been served on me.
25132, Milord, the Simons, last but one.
You don't want it to be disposed of. You.
Yes, then I will file.
No, dispose of what,
Serve a
sir?
copy to me, then I will give a counter.
Which item?
Item 14, my lord. I think
14, yes, Sims College.
Yes.
Oh, yes, Sims College. Give a copy. My lord.
Yes.
4 weeks.
And the last one, my lord, Bethonati, he has given a
File
copy to.
affidavit in this case.
Yes, my lord.
Yes.
The last one is Bethonati School of Nursing, my lord.
Yes.
She has given me a copy to me. I will file a counter to this case.
Yes.
Item 57.
Fifty-seven, my lord, I have in all the cases. These are the matters where the deficiencies were complied online, but after the date fixed, 14 days after. That is to be hard, and this similar matters are there. All counters have been filed. A date may be fixed for hearing the matters, my lord.
Why? We can hear.
Yes, my lord.
Yes, who is in the first case?
My lord.
Who is in the first case? Noble Institute.
First case is
Noble Institute, Miller, they have filed the counter affidavit, Miller. I am seeking for to file my reply, Miller.
Very good.
So
How much?
Miller, within just after the reopening of the vacation.
My lord, let all these matters. My lord, all these matters are similar nature.
So
So
same
let
day.
it be fixed after vacation, any date. So all these matters can be disposed of
Fix it.
any date.
Counter where you have to give.
Yes, I have given counter. Most of the cases I have filed counter. They have to file agendas.
You're fixing it to 11:11.
Yes, my lord.
Let the rejoinder, if any, be filed on behalf of the party.
Item number
नहीं सब आइटम रखे क्या करना है
all in 57.
All 57.
All these petitions.
Item
All-
63.
Yes.
so 57 all on 11.
Yes. My lord, 11, it's better let it be last week because in nursing matters, date has been extended up to 31st of October.
31st of October.
Pharmacy only up to 30th of November.
Tell us which is pharmacy, which is nursing.
These
These
are
are all nursing matters, my lords.
These are all nursing.
Nursing is up to 31st of October.
Please, one moment. So all, so item 57, it has to be before.
Yes.
Yes.
Right, 29th or 30th.
28th.
Yes, ma'am.
Then only that 57. Previous
Yes.
matter is fine.
Yes, ma'am.
63.
65, 67, all the same.
63 is the
63 also the same, my lord. Not submitted in time.
No matter.
No. Your lordships may take up sub-item 2 in 63, sub-item 2 and 3.
Yes.
Then the reason which has been given, if your lordships would see their counter affidavit, the reason for cancellation which was shown or the defect which was pointed out is at annexure 4, page 42, your lordships may see.
Yes.
There they said teaching experience certificate of principal as per required. That was the only defect.
Which one?
Subsequently, they cancelled it saying that there is no fire NOC. And I had pointed out before your lordships in their counter, they have filed the report which is supposedly given by the deputy fire officer, where it has been mentioned that whereas the said certificate has been cancelled, withdrawn with effect from 3 to 24 due to some unavoidable reasons, and no notice was given to us. Your lordships had directed even the fire government to file their take instruction and file the response that what was the reason, because the fire certificate was valid till 25 September.
My lord.
If your lordships remember.
Yes.
My lord, in this case, my lord, after hearing, there was direction to the state government to file the counter from the fire department, they have filed. And there was a direction to give NOC subject to decision. We have already given NOC to these two institutions. Only the academical that is to be decided. We have already given NOC to this institution.
Yes, then your lordships might take it up subject to hearing for whatever dates your lordships must fix. Since NOC has been granted, they can pursue, so it can be heard later on.
They have already issued the NOC.
But this
Yes,
year.
these two, subject to decision of this case.
Okay, then it need not be October, it can be beyond that.
Yes.
Any day after that even. On 11/11, your lordships are
11/11
fixing
can be
the
done.
other matters. This also can be, or any date subject to your lordships' convenience.
Why should they be understood? Let it be on 28th.
Yes, my lord, no problem.
Item 65.
65 also, my lord. I have filed counter. Not submitted time, they have to file agenda, it will fix on NOC matters. Maybe fixed to that 28.
Nursing, so 28.
Yes, 28.
My case, 200.
These are those technical glitches.
66.
Yes.
Only, my lord, 66. Item number 3. Sadhguru College of Nursing denied online inspection, my lord. So we have to reconsider the case of the petitioners.
66.
Yes, 66.
Yes.
And the next Satyanarayana College of Institution, my lord, it is not regarding NOC.
No, that's what did you say?
Sadhguru, he couldn't got the inspection on the date with the plea that there was some repair work. The next day it was intimated to us, but we have not taken care of that. In this case, because everything is there, we should go for inspection and get the NOC.
So direction has to be issued to you to inspect
Yes,
the
yes,
college.
yes, yes. Within, when it did.
2 weeks. So before.
6.3.
Between 16, there is, offices are open.
6.3.
Government is open on that, those days.
Within 2 weeks you should.
Yes, ma'am. Yes, ma'am.
Within 2 weeks, you can.
Yes, ma'am.
So that is as regards 3 only.
Yes, ma'am. Then, my lord. In Mother Teresa, my lord, that is item 70.
Item number 66.
My lord,
Just a minute. So how many cases are there where the applications have not been submitted within time?
Yes, my lord, I have written here.
That is there.
Not submitted in time.
So there can be a bunch of those cases.
Yes, yes, that can be fixed or hearing.
So that can be taken up, be it pharmacy or nursing.
Yes, ma'am. Mostly nursing matters.
So who are like giving an example, who is appearing in Chatoi school?
But I am appearing.
So you have not submitted within time.
But now my application, online application was on time, my lords. They rejected on the ground that other than the document that I had submitted, there 2 more documents were required, which was not a part of the online application requirement. That I have submitted, which according to the counter, that I have submitted belatedly. My ground was the ground of rejection on clause 6 could not have been taken because clause 6 required an inspection to take place. After inspection, if they're not satisfied, and a hearing to be given. So therefore, clause 6 could not be the ground for rejection in my case. And they say that we have complied it, but belatedly. Our also case is that there was a glitch in the system, which is why they did not accept our regular email ID. A new email ID was given, which was Google accepted it to be a spam. Therefore, I'm sorry, my apologies.
In this case, my lord, I have filed a counter. Earlier, he was filed a case petition to 12693, my lord. I have given in my counter. There, the matter was before my lord on 18/6/2024, reopening day of the courts. That day, after arguing for some time, he has withdrawn the case with the liberty to file a representation before the authority, which my lord disposed of with a direction that if he files that will be taken for the next session. See, that case is also for 24-25. Now again, after that, after the representation, he has again filed this case for this 24-25. He should have applied for 25-26.
24,
which is just hard.
25-26 minutes.
Because he has already filed the case.
Online application will never be there for 26 minutes.
Hear it before.
Yes, ma'am.
31st.
How can
Yes,
I do that, ma'am?
Before 31st can not. I have filed the counter in this case.
Yes, my lords, in the counter they say, my lords, that since this honorable court
Yes, let us see.
My lord, item 66, last but one sub-item.
Yeah.
In that case, my lord, they pointed out the defect, stating that valid hospital affiliation not submitted. The lordship knows that valid affiliation certificate can only be obtained after I get the NOC, not otherwise. Because prior to NOC, the hospital will not grant me the validation or the affiliation certificate unless I have the NOC in place. And rest all, everything has been complied with. They have stated that valid hospital affiliation not submitted.
Oh, my lord, they used to get the affiliation. If he get the affiliation from that hospital, we will give him NOC. We have no objection to stay back.
No, what he is saying that unless you give him NOC.
No, my lord. In most of the cases, they are giving the affiliation, then we are taking into consideration NOC. The last thing I told.
See, in most of the cases will not or cannot be procedure. You will have to tell us.
Yes, my lord.
If according to your guideline it is required.
Is my lord required? It's required.
Before NOC.
Yes, my lord.
It is required.
Yes.
Then we will see.
Yes, my lord.
Lordship, may I, in that sub item itself, the valid hospital affiliation is something different. That has to be procured from OUHS. And in the NOC, it has been clearly mentioned that we have to procure the affiliation after we get the NOC.
That is clearly there in the NOC. Your Lordship may kindly have a glance at this. Page
Affiliation what?
affiliation from the OU,
DMET.
Odisha University Health Science will.
He's telling DMT, he's telling application for university.
Affiliation is another aspect altogether.
Your Lordship.
Mr. Nanda is on some a different issue. The question is that according to him, at the time of submission of application, affiliation with hospital is required.
Yes.
So Mr. Nanda is saying that unless NOC is granted, a hospital will not grant affiliation. But if the procedure requires that there should be affiliation, there should be affiliation available.
Let it be hard, I would give all the documents.
Huh?
Let it be hard in the next statement.
You can hear it right now. Yes, what about other cases? We will take up.
So 5, 6, 7. 5 also in
5, 6, 7.
Yes, madam.
Valid hospital affiliation not submitted. How many cases of this nature are there?
So
Only one, madam.
Only one. All right. We will see. Now let us come to the next cases. Not fit for recommendation. 7
Deficiency not complied with, madam.
Six is over.
Yes, I have already filed the counter.
66 is over.
66
is over.
5 Lordship is keeping to some other date for him.
65. Yes, 65, 66, 5. We will consider on the next date.
My lord.
All such cases where the remark is not submitted within time.
Yes, madam. Yes, madam. Yes, madam.
Yes.
Item 70.
So this is nothing, so it will go to
58.
28 on that day we can.
No, who is there for 70, 70, 71, 70, sub item 1 and sub item 2.
70, item 1 is, my lord, he has not complied with. I will file counter ready. I will file the
Who is
counter.
there? Who is
Item
there for the
70.
petitioner? In these two cases.
Yes.
70.
Nahi hota hai.
Yeah, where that will be taken up first.
Counter is ready. I will file it. Counter is already ready.
Where is Miss Patnaik was here? Where did she go? Miss Patnaik was here.
Mr. Patnaik is on, your Lordship, he is on his legs.
Not Mr. Miss. Item 71.
70.
Huh?
Is
71.
70.1.
The Sethi is also not there.
I will file counter in both the cases.
Counter.
Yes, madam.
One.
71 and 2.
All right, file counter.
Yes, madam. Item 3B is agent.
So you file counter, we'll take it up on 28.
Yes, madam. 70, my lord. It's pharmaceutical college. Didn't cooperate for inspection. We fought for inspection, and the inspection he didn't cooperate.
Which?
All right.
Because pharmaceutical college, my lord.
That's 3. Not cooperate. So what do we do for that? The Mahapatra is there. It's not cooperate now. Again, it's cooperate.
No, we'll dismiss.
Counter is there. Yes, Mr. Mahapatra, your case. Counter filed.
Counter I will file.
Copy not served.
I have served the copy and counter to file.
Counter your file.
Yes, my lord. Copy has not been given. I will give the copy.
Copy not served. Serve a copy.
Yes, my lord.
28 tab.
Then, my lord, the Mother Teresa College.
Counter file.
Counter I have not filed. The fact of the case is, for 24-25 he was not applied for, but the NOC for 23-26 was given later on later stage. So he couldn't apply for the 24-25.
That I think is covered.
Oh, that we can say that direction, we can give an inspection to that, and
No, but he has to apply, that means.
yes, that is we have to apply. That is the cover
For a
of that
particular
case.
date, he has to apply, then you can inspect.
That was up to 30th of August.
Where did the council is here? You're
My
right.
file-
I will file counter, my lord.
File
If
counter.
you file
Yes.
counter, when
Yes,
will
madam. I will-
will he apply then?
Yes.
Then let him apply in the meanwhile.
Yes, my lord. Let him apply.
We have already applied.
24, 25, have you applied?
Yes, there is a 23, 24.
24, 25 he has not applied. 24, 25 he has not applied. 24, 25 he has not applied. Let him apply, we will consider.
My lord,
You got it late for 23, 24.
once my application was pending, they considered me, but they consider the other cases, but not my cases. I have annexed all the documents where they have allowed the NOC, but they have not, they have.
24, 25, had you applied?
No. He has not applied.
24, 25, I have not applied.
Then
That
Yes,
is what I'm
ma'am.
saying. Your
That's
case was allowed for 23, 24, but delay after the session
yes,
was over.
yes, yes,
In those cases, they are considering for 24, 25,
Yes.
provided you apply.
yes, my lord.
how can you do now?
It cannot be done.
Can he apply?
No, my lord. Now the time is already over as per my lord direction, 31st of August.
Yeah.
No,
I
he
have-
can apply for
I
25,
have
26.
applied for that, inspection date has been also posted.
Correct?
I have applied, the inspection date has been posted. It was posted to 5th and thereafter it was subsequent.
24, 25.
Yes.
No, no, I will give the counter to this case. Let me get the verification and all these things.
Meanwhile, you process if you.
Yes, yes, ma'am. If it is there.
As per.
Yes, ma'am. Yes, ma'am. Then the next one is, my lord, he was asked to personal appearance of on the date he failed to attend the. And he has to, before the DMT, with all necessary papers, date fixed.
That is covered by your lordship order. I am providing a copy for the
But in your table, you have not given that.
No, that was not given because he is telling that he couldn't produce himself on that date. So as you are giving for one scope for them, let him appear on 14th before the DMT with all necessary documents, as he was supposed.
What is that decision which covers him?
I am providing for the lordship.
So I am giving. Give it to. This is synergy.
In synergy case, I am providing a copy.
No man.
Milord, I am providing that is
Denied for
19152 of
19152.
2004. Disposed of on 14/8/2024. The next one, my lord, I have filed the counter. That is the same, not submitted in time, that you heard on the next list. Then, my lord, 77/3.
please let the cases be called.
Yes. My lord.
Council should be there.
Item number 70, sub-item 70.
70 sub item 7.
70, sub-item 6.
Yes, ma'am.
20930.
Yes, ma'am. For renewal purpose, I have submitted online application with all requisite documents. They have rejected my case that annex of 5, page 27 starts from page 27. The relevant portion at serial number 71 says fire safety certificate not compliant.
Yes.
Lordship, see the annexure 2. This is the certificate given by the Deputy Fire Officer Barampur. After due inquiry, they found, whereas the obstructed building was inspected by a team on dated 15th May 2023, and it was observed that the construction of ground floor of the proposed second story building has been completed at present. Keeping the view of the structural parameter and the proposed occupation of the building as per the plan submitted by you, it is ascertained to be not coming under the ambit of the Orissa Fire Prevention and Fire Safety
My lord, I have filed the counter.
Hence, it is not required for you have to fire safety certificate for the said building for the proposed occupation of nursing college. This is there.
What is your course?
That is BSc nursing course renewed. On basis of this, last year they have renewed. Now this year they have.
My lord, BSc nursing, we want 47,340 square feet of build-up areas. If that is there, the fire certificate has to be given. He was telling G1 only less than 1,000 per square meter. So that's why I have given a counter. Let him give a regenerative today, let it fix on that date. That will be finalized.
Yes. 20. Next.
20989 of 2024.
In that case, I am on behalf of the petitioner. It is sub-item 5, it is covered as per my understanding. I just actually on it. Covered, let him say. We will not pass order like that. Let him say whether it is covered or not. 7.
It's one.
Now it is sub-item 4.
It is also, my lord,
7.
he was asked for personal appearance on 14/6/24 with relevant documents, but failed to comply. So he, my lord wants, he can appear again on 14th and produce the documents. If it is found, we will consider.
You can appear. We are not passing any order.
Yes, my lord.
We will keep it to 11.
Yes, my lord.
We'll go to 11. Before that,
Yes.
whatever you want to do, do it.
Milord, it is a nursing matter, Milord. It will be, that session will be.
Oh, it's nursing.
Yes, this is nursing.
Then 28.
28th.
No, he will appear.
Yes.
He should appear when?
Appear on 14th? You can
14,
appear on 14th, 14, 10.
10 you go there, you want.
Yes, yes, ma'am. That one,
Don't
that day
go
you
there,
appear.
we will not entertain.
If you appear,
Yes, yes.
you will.
Yes, ma'am.
No.
You will go on to 14 then.
Yes, ma'am. The same order has been passed, ma'am.
Same order has been passed.
Now, in other cases, to appear before the DMAT.
Which item?
So that has been disposed of.
19152 of 24.
That has been disposed of, not urgent. Because you said it
This
is
can be
covered.
disposed of. This can be disposed of.
Why did you say it is covered?
No, no, my lord. Covered in this says the principal's appearance. That is, my lord. 19152.
Yes. 20561.
Yes, we have disposed of that one.
19152 of.
70.5.
Yes.
So two similar matters he has,
Yes,
statesman and ISA.
Yes, Milord. Correct.
21095.
May please, may please, your lordships. My lord, in this case, we have complied with the deficiencies within time, by which was prescribed by them in Annexure 9. Lord,
I know this is pharmacy.
they have
matter.
rejected
To
on
file
the
counter.
ground that
Let him file counter.
Yes, ma'am.
Lord, my learned senior may file the counter before vacation so that we can file the.
My lord, this is
within
pharmacy matter.
time.
When did you file the writ petition?
The writ petition was filed on 27/8/24.
So
It's a pharmacy
27/8,
matter, my lord. It has been
just,
extended. Up to 30th of
27/8 you
November.
filed.
Yes, my lord.
When did you serve copy?
My lord,
Time had been granted for filing counter, you have not filed.
Yes, ma'am.
I have served copy, I think,
No,
the first week of.
He says that it is end of November time.
Yes, my lord. I will file the counter because there was some mishap and all that. I was
All right.
completely out of sight, my lord. Due to mishap and all that.
11th, you have to serve it by before.
Yes,
that.
my lord. Yes, my lord. I will file the counter and sub to him before that.
Yes.
The next one is also
297.
21297, I'm here.
he absent in personal hearing on dated 7th filed to submit documents within time. That same principal to appear before the authority.
1410.
Yes, my lord.
1410 principal.
21342.
Then this is, I have to file the counter and these are all not submitted in time matters. That is fixed for 28th for hearing, my lord.
21431.
Yes. All these. Up to.
That is 21342 have getting counter. And some time to file rejoinder. Come on a reopening day so that because
It's all fixed to 28th.
30th October.
28.
28th.
My
My lord, up to 1676, up to 21513, my lord, all submitted. This counter is filed, and if not filed, I will file and give the copy to them. This is fixed to 28.
28.
Then the last one, my lord, Vikas Pharmaceutical College, principal detail not given, he can appear before the authority, the 10th, 14th.
21714.
Yes.
Yes, my lord, that is principal to appear before the authority on 14th.
Yes.
Item 71.
My lord, here, I have filed the counter in this case, my lord. So he has to give reliance. This is the GNM course. It will be the same, it will be fixed to 28 for hearing, my lord.
28.
Yes, my lord.
Item 77.
77 also one. The same, not submitted within time. I have filed the counter to be filed. Same 28.
Item number 81.
Item 77. Item 77, item 2 the deficiency not complied within time.
Which item, sub-item 2?
Yes, my lord. That is 28 that is fixed for hearing all the matters.
And sub-item 3, your lordship, in this method, it is rejected for denied for online inspection matter. They have wrote the letter on
Which item? Which item?
77.
Sub-item 3, your lordship.
Dispose of 3. The correction.
Item 77, sub-item 3.
What is the case? Yes.
WPC 20648.
So you will be considered, Mr.
Yes, my lord.
Your case is covered.
No, madam.
So you will get another date on which they will do inspection.
Yes, my lord.
The inspection which day?
Any date, my lord, within 2 weeks.
They will do it.
So you fix the date.
Yes, my lord.
20648.
Yes.
Yes.
Item 81.
You are my lord. 21716 of 24.
This is also covered.
Yes, my lord.
No, my lord.
Denied for inspection.
Denied for inspection, not my lord, denied for inspection. They have not wrote the letter.
Already they will conduct inspection.
My lord, already we have taken care of this case. We will inspect and see the NOC is given. The letter was not given, but subsequently we have given. My instruction is we will consider the case of the petitioner's institution because we could send the letter. So he will be inspected and the NOC will be given. That is my instruction.
Given.
Yes, ma'am.
How do you say?
No, NOC has to be given after consider.
After inspection.
Inspection. Consider will be considered, my lord.
Yes.
20490. 81.2.
Counter.
In this case, my lord, petitioner applied for renewal of NOC for B Pharma course, but the DMET has granted for D Pharma course, my lord. Next 12/27, my lord, have granted.
My lord, I will file the counter. It is a pharmacy matter. So
But instead of issue renewal of NOC for B Pharma course, they have granted for D Pharma course.
Very
I will
good.
file the counter. I will file a counter in this case. What has happened? I will file a counter, my lord. Why? How they have given the D Pharma instead of D Pharma, B Pharma. I will give a counter to this.
You will give a counter, but B Pharma, why are you not? If he has for D Pharma, for B Pharma also.
That is not how it has been done. In other cases, my lord, other cases, the same. Denied of NOC, my lord, fixed to 28. Other cases.
Nothing. 28.
Yes.
Actually, the counter factor.
All other cases.
My lords, your lordships will take up that item 66 sub-item, that affiliation.
Yes.
My lord, your lordships are taking up that affiliation issue.
Yes.
Which my
Affiliation with health, some
with the hospital. So your lordships will take it up, Lord, today or
after holidays, it cannot be taken up.
all right.
The item 18, ballot. 18. That matter, it was taken up on Friday. You remember that mosquito net. 18, it is there. Once I heard that a lot of matters are there. Tomorrow we'll take up. Tomorrow, little bit up in the list if you lordship can read. Tomorrow.
But reservation, that matter for OP number 7.
For OP number 7. Yes, better.
Supply that he makes all the time.
So you are the net.
But no
You
copies,
are,
no copies have been given to us. I'm expecting that it come after vacation.
let us see.
And the reason why no supply, all the supplies have been made, but no distribution will happen unless the second sampling does not happen. So there's no hurry. It can be taken up on the first day.
So we have to say that there is
Tomorrow, you should hear the matter. It has to be clarified. No distribution should be done Because till the matter is over by the registering.
Not because each mark has to be again sample. That's there in the tender condition. So
Who is for the other state?
So-
We will take up the matter tomorrow. Tomorrow, that's right.
the advocate on record, he would be out of station, so that's why, and his matters come suddenly.
Authorize someone else.
The senior can be replaced, but the advocate on record cannot be replaced.
Yes, he can.
But we have not issued notice, so if he doesn't appear
There is
also.
no question of replacement.
Because
It's a
that's exactly what they want. They want an order against her.
No,
You are
no,
saying-
against anybody.
You are saying an order, you want us to pass that order.
No. What I'm saying is that there is no hurry. We will file a written.
Madam, we can
representation.
assure you that we shall not pass any order which will be detrimental to your interest.
Right.
Without giving you due opportunity.
Yes.
All right. So just, we will take up, it will be
Tomorrow,
there within
yes, ma'am.
first 5 cases. We will see.
Mr. Mahanti, you're going out of the country?
Not out of country.
Okay.
So ask someone else to assist her.
Right.
Yes.
And that is an assurance from the court that no order can be passed without due opportunity. So many things have to be taken care of, including public interest.
Plus with this another matter, item 23. That's also an urgent matter. We require
And also
interim protection.
What is-
You can come tomorrow, Your Lordship.
What is that?
It's a tender matter, Your Lordship. There's an urgency. We have been rejected without any reasons.
All right.
And it's apparent on the face.
These have come on mention. We'll
All
try
right.
to take.
Tomorrow we will not take up any matter other than those which are urgent. So tomorrow you make a mention.
Item
11,
item 11 is a tender matter, my lord. Item 11, but techno tomorrow.
Yes, all these fresh.
No,
and-
only urgent matters tomorrow.
Item number 39, my lord. So on the last date, your lordship was directed to take instruction whether the corporation is ready and willing to go for fresh tender. We have filed the affidavit. It was in the list last week, it did not reach. So may I pray your lordship may take it up in orders tomorrow?
You are for whom?
I am for the corporation, my lord.
Who is for the other side?
Beverage corporation.
Who is for the other side?
Other side, actually, I have not informed him. So I will inform him, my lord.
Inform him, come tomorrow.
My lord. Lovely.
Item number 16 and item 53, my lord. The tender matters, my lord. Item 16 and item 53, tender matters.
Item 22, my lord.
We will see tomorrow.
Item 22 is a fresh matter of tender matter. My lord may be taken up.
My lord, item number 16, my lord.
All fresh matters are getting stale.
My lord, item number 69, that is admission matter, that student, handicapped student. Handicapped student admission matter, item 69, my lord.
Which court?
My lord, other advocates I have called, sir.
Which course?
That is BTech, my lord.
Which college?
My lord, he admitted in the, she admitted in the Synergy College, but wants to go to the Bhubaneswar Gita College where she has obtained the NOC. Synergy advocate, Mr. Das was also there. I have served the copy. I have also served all others copy. Because it is the urgency, my lord.
So who is for the college?
Synergy College, Mr. Das was there.
PP Das.
Just sit with him, have tea with him.
Yes. Let it come tomorrow, my lord.
My lord, item 15, my lord, may I pray day after tomorrow because urgence.
You're sure? You want
Because
to do what you're sure? You
Pardon?
don't want to find-
Ninth at what time?
My lord, the place because it is the urgency is there. Cut-off date is the 25th October.
Matter is urgent, then try tomorrow.
Tomorrow.
All fresh. will come.
Yes, all right.
will come. But item 43 is not fresh. That is my problem.
We will see.
53, item 53 is not fresh. That's my problem.
I had undertaken to prepare a note for
The bank and trust.
Yes. So if your lordship will.
After holidays?
Any date your lordship fix convenient to lordship so that.
After holidays, at 2 p.m.
I have a similar whereby it's 51. But what's happened, notice had gone to the government, they have supported us. Unfortunately, the matter is not reaching. Once the policy decision of the
You, in Gudia, you call 50, Patti.
No, madam, not today, but
Patti.
I'm not even expecting today.
Patti is going on there.
No, I'm not expecting today, madam.
Khatti, sorry, Khatti.
I only request, madam, for any specific date, I'll be deeply
Yes.
obliged. Madam, I mentioned it earlier, my lord was pleased to directly be listed on a particular date. Unfortunately, it didn't come that day. It was fixed at 2 p.m. my lord, on my email. Any date, my lord, may fix because it's harming small industries, my lord.
We'll give a date.
I'll be deep. 51.
Which date? 12th November? Will it be?
Fine, my lord.
2 p.m.
2 p.m.
My lord, item 56. So, my lord, item 56.
Yes.
My lord, petitioner's admission in BMS has been cancelled. My lord, I pray today not possible any specific date.
Later. Later. Make a mention later. Yes.
Matter fixed for 2 p.m. here. Item number 34.
May it please, Your Lordship. Lordship, Lordship, I'm appearing in sub-item 5, in item 34. The SLAL trades and agencies, my lord, sub-item 5.
But you had not finished your submissions last.
Lordship, no, I just started on the second matter, Lordship. Lordship.
Today, if I.
I mean, Mr. Singh, had you not finished?
No, Lordship, I started.
IMS portal.
No, that's done. This is another matter. That is done. Let's have to finish. Lordship is correct. That I've done. This is another matter, which is sub-item 5.
So how much time will that take?
Maximum 15 minutes, Lordship, by the clock. I won't take maximum. If a Lordship may, Lordship, here, unlike 23 leases, which were expiring on 31st March 2020, this lease expired on 26th May 2020. Lordship, note that expiry period that 31st March 2020 by virtue of section 86 of the MMDR Act. The same provision also provided that it will be 31st March or after 50 years, whichever is later, after 50 years of the grant of the license, lease. So in my case, the lease, because it was granted 50 years before, this expired on 26th May 2020. So Lordship knows if I calculate the 6 months, I'll go to the end of November and 1 more month will take me to end of December. Lordship knows GG and HH. I don't need to tell my Lordship that. So my 6 months will expire on 27th November and 1 more month thereafter, HH, 27th December 20. So what I did 2 things, my lord. One, much before the expiry, I made a representation like all other lessee for extension of period beyond 6 months on account of force majeure that I made on 3rd of August 2020. What I also did, my lord, and much before expired, 2 months before the expiry of the period, on 28th October 2020, was an application for intermediate storage condition. My lord has been taken to that 4th October 19 notification for intermediate storage permit. Under that notification, I made an application 2 months before my expiry of the 7-month period on 28th October 2020. Now that application of mine was recommended for the grant of intermediate storage. Lordship, that recommendation is at page 91. Lordship can just make a note of it. I don't want to. It was recommended on 30th October 2020 for grant of intermediate storage permission. Unfortunately, on 9th December 2020, and that's a bit important, Lordship, 115, that application of mine is rejected. Rejected on 2 accounts. Lordship, it's a 1-page order, but I just placed that. Lordship, because my submission is only going to be on intermediate storage. Nobody else has argued that. Insofar as force majeure is concerned, I'm going to adopt the argument which has already been made before, my lord. Page 115, annexure 14, is that impugn order rejecting my intermediate storage application, despite recommendation. Lordship, I have the last paragraph at page 115, annexure 14. May I place it, my lord?
Please.
Last, whereas the Director of Mines, Odisha Bhubaneswar, has clarified in this regard with a letter dated so-and-so and clarified that as the applicant Lal Trades has applied for intermediate storage depot on 29th October, i.e. after the expiry of lease term, that is 26th May 2020, and the said notification only applicable for those leases which were expiring on 31st March, the above government notification dated so-and-so is not applicable to the instance. So two reasons are given to me, Lordship. One, I applied post expiry of my period, and two, I am not covered in the notification, but that covers 31st. Against which, Lordship, I came before my Lord, first round. By the time I came, Lordship, the first round, already the 22nd December judgment had come, my Lord. So I was relying upon that judgment as well. In my case, Lordship, I have the division judgment at A15, page 117. This is my first round, page 117, A15, annexure 15. Lordship, I have page 119 straight away, bottom, para 7. In fact, para 6, I just want to indicate to my Lord. Para 6, last 6 lines at page 119, and para, I'm so sorry.
Yes,
my Lord.
119.
Yes, Lordship, 119, at the bottom is para 7, there were 6 lines before that. This is my submission, my Lord, on the basis of the earlier judgment. And para 7 also, Lordship. This is on the first ground of force majeure. Lordship, I come to the next page, 123rd line from the top. This is my intermediate stories permission submission. Mr. Sarangi further urges that his case should be considered beyond and confines to the notification dated so-and-so, and that the facility of storage license should not be denied only because his lease period expired on 31st March 2020, but on 26th May. Para 8. The court is unable to agree with the above conditions. The said notification issued in a certain context and the confined to those leases expired on so-and-so. It's not possible this could extend the scope so-and-so. Now, Lordship may now note, Mr. Parija at this stage informed the court that out of those who have been granted the storage license, only one availed the benefit and he too did not really utilize the facility. 9. In the light of above submission, it is directed that the petitioner should make a comprehensive representation to the secretary to the government so-and-so, placing before him all the contention raised herein in this writ petition and the material, including the material on record of the present petition, and pray for extension of time for removing the entire stock of minerals. Further, the Secretary Department so-and-so will adjudicate whether petitioner had made out a case of force majeure within the meaning of so-and-so, and Lordship may turn over the page. If the petitioner is able to make out such a case, the Secretary will grant appropriate extension so-and-so. If the petitioner makes a comprehensive representation, grant so-and-so, within which will be permitted to remove the entire remaining stock of material. If the petitioner makes a comprehensive representation not later than so, Secretary will adjudicate and the representative take a decision so-and-so. Now, Lordship, pursuant to this, we made a representation like less of the lessee, on which the present impugn order is passed, which my Lord will find at page 210, annexure A90, 5th May 2021. Now, Lordship, insofar as the force majeure is concerned, Lordship, they rejected, Lordship, like all other cases, they all clubbed together. One instance, they did not take the peculiar cases. Lordship, I don't want to really, it's the same case, I adopt the submissions for everybody. But one finding I wanted to show to my Lord on force majeure, which is relevant for my second submission, for intermediate storage permission. That one finding, Lordship, will get at para 20, page 223. This is a finding, the reason given by the Secretary for rejecting the force majeure argument in my case, which in my respective submission may be a bit relevant for my second submission. So I'll just place two paragraphs, para 20 and 21, which my Lord will find at page 223, top. It is relevant to examine here whether the petitioner was in any manner differently placed than the other ex-lessee whose mine lease has expired along with the petitioner, and whether the provisional rules so-and-so were applicable to the petitioner or not. Upon scrutiny of the fact, it transpires that the petitioner was one of the 24 lessees whose mining lease has expired with only one exception, that his lease expired on 26th May, i.e. 56 days after expiry of so-and-so. He therefore is equally placed with all other 23 lessee. The provisional rules so-and-so are equally applicable as per law to the present petitioner, and the petitioner under obligation to remove within 6 months so-and-so. The answer to this question is therefore in the negative. There is nothing which places the petitioner in any different footing than the 23rd lessees whose lease expired on 31st March 2020. And para 21, my Lord, the same view is reiterated in last 3 lines. In view of the above, the case of the petitioner lease is equivalent to those of other 23 lessees which expired on 31st March 2020. Now, my Lord, may come to their consideration of my intermediate storage argument, Lordship, which starts at paragraph 33, page 228. And this is what I'm placing before my Lord. Rest I'm adopting the submission. This is my peculiar case, intermediate storage permission. Paragraph 33, 228. Further, that all the above 24 mining leaseholders were well aware of the validity of the lease period. The state government visualizing that the concerned lessee might not be in a position to transport the whole mineral stacked on the leasehold area on consideration of representation instance of association issued a notification dated 4th October. Lordship knows about this. I'll skip, is quoted in paragraph 34. My Lord may come to page 230 now. Paragraph 34. That although the said notification dated so-and-so was applicable to all the lessees whose mining lease they are expiring on 31st March 20, the subject matter notification clearly indicates the benefit has to be extended to lessee of expiring lease for removal of the extracted minerals so to facilitate smooth operation by new lessee. That all the above should be 23 mine lease were well aware of the fact that the lease period would come to an end on 31st March 20. The state government visualizing that the petitioner might not be in a position to transfer the whole material stacked on the leasehold area on consideration of the representation and instance of association issued a notification dated 4th October 19 and provided each of them to the scope of intermediate storage with a further additional period of 2 years up to 31st March 2022 with permission to sell all such minerals in the open market. That the petitioner lessee, although was aware of the expiry of his lease on 26 May 20, did not pay any heed to the above government notification which was brought out on as early as October 19. That is more than 7 months prior to the expiry of lease. The petitioner lessee did not make any efforts before the state government to avail the same benefit before the expiry of the lease. That the petitioner applied for the minerals so-and-so on 28th October, that is after 5 months so-and-so, which indicates lack of proper planning by petitioner so-and-so, complete evacuation so-and-so, and lying undisposed on the date of expiry of the lease. This is the ground on which my request for intermediate storage permission has been rejected. And our Lordship need to make 4 points. I need to just state 4 points, Lordship. That this view is absolutely arbitrary. In fact, it's contrary to the 4th October 19 notification. Point number 1. There is no such condition in 4th October 19 notification that I have to make an application prior to expiry of my lease period. In fact, Lordship, what is relevant? Lordship, I have 6 plus 7, 7 months after the expiry. I have that buffer. I need intermediate storage after 7 months, not on immediately expiry of my lease period. So this is, in my respectful submission, an incorrect view which has been taken. In fact, my Lord, I placed it in my writ petition and I annexed those instances as well. This is exactly how the government understood. I placed instances where the applications were made after the expiry of the lease in October and intermediate storage permission was granted within 1, 2, 3 days. Lordship, may I have page 7 of my writ petition?
Yes.
I put those instances, page 7 bottom, Lordship. I put the instance 1 of KM Ram, applied in October, expiry 31st March, applied in 16th October, granted on 20th October. Ghanshyam Mishra, 31st March expiry, 21st September applied, 24th September granted. In fact, I have more than these 2 instances. My colleague has carrying those instances. Within 3 to 4 days, they were granted, Lordship. Application made post expiry of lease period, but before the expiry of the 7-month period. My case is also, Lordship, before the expiry of the 7-month period in 28th October 24, which was recommended on 30th October 20, in fact. So, Lordship, this distinction in my respectful submission is an arbitrary distinction, is without any. This is an artificial distinction in my respectful submission. And in fact, contrary to the notification itself, which does not carry any such condition. My submission number 2, my Lord, as I already indicated. Number 3, that I don't need to apply before that, which I've already made, Lordship. It's only after the expiry of the whole period I need to apply. And there's a distinction. My last submission, my Lord, on this is that in fact, when this court on 28th October 28th January 21 passed that order for consideration of my case, that order effectively has been made OTOs. Effectively has been made OTOs. Because on that day itself, I was non-compliant according to the secretary. I should not have been granted. So therefore, on discrimination, my Lord, artificial distinction, not a condition. Date of application, what is relevant before the expiry of 7th month, not before the expiry of lease. And it's a clear discrimination, Lordship. These are my respectful submission, Lordship. And when you say at para 2021, we are similarly placed like other lessee. For intermediate storage, you're saying we are differently. Well, that's my last submission on this point, Your Lordship. Therefore, in my respectful submission, this view, Lordship, is absolutely incorrect. And I'm entitled to an intermediate storage permission, and I don't need more than 60 days, Your Lordship. I'll put it in intermediate storage and clear it from there, Your Lordship. This is my additional submission, Lordship. In so far force majeure is concerned, Lordship may record that I adopt the submission which has preceded me, Lordship. I'm so grateful, Lordship. I hope I've stuck to my 15 minutes, my Lord.
Thank you.
Grateful, Lordship.
Yes.
May I please, Your Lordship? Before I respond to the contentions of the case of the councils, let me first highlight some of the statutory provisions from the MMDR Act and the rules framed thereon. I have made a compilation of some of these statutory provisions. Yes. Your Lordship knows.
Yes.
Lordship knows that there was a very progressive amendment in 2015 and certain provisions were inserted in the existing law, MMDR Act. The whole object was to divest the state's property, its public property, Your Lordship knows, and to fetch more revenue by putting it to auction. 3-4 important provisions. Let me just draw Your Lordship's attention. That is section 8A of the Act. That is most important. So let me begin from that provision. I have made a compilation of the provisions. If Your Lordship may refer to the book also, that would be fine. Otherwise, I can read out from this provision. MMDR Act. Section 8A, Milord, which came into force with effect from January 2015, Milord, postulates two things. That in no case an existing lessee would be entitled to retain the leasehold area beyond 31st March 2020 or 50 years, whichever is later. So therefore, all those lessees will not accept the last one, Lal Traders, which Mr. Singh, my learned friend, was arguing as the last case. Their lease period came to an end with effect from 31st March 2020, Milord. That is the cutoff date. But in view of subsection 6 of section 8A, as soon as the lease period, Milord, either has expired or due to termination, which may be another eventuality, the property vests with the state government. But there are two kinds of vestings which is postulated under the Act. One is a vesting which is, Milord, envisaged in section 8B read with 8B of the Act read with Rule 9A of the 16 rules. And another vesting is, Milord, contemplated under Rule 12(1) HH of the rules. Let me, Your Lordship may look to section 8A first, Milord. Glitch for minerals other than coal, atomic minerals. The provisions of this section shall apply to minerals other than those specified in Part A and Part B of the first schedule. There is no dispute that all those lessees are, Milord, iron ore lessees. On and from the date of commencement of Mines and Minerals Development and Regulation Amendment Act 2015, all mining leases shall be granted for a period of 50 years, not beyond this, Milord, period. That is the maximum period for which they are entitled to hold the leasehold rights, mining rights. All mining leases granted before the commencement of the Mines and Minerals Amendment Act shall be deemed to have been granted for a period of 50 years. Whatever may be the period, the maximum period is 50 years. On expiry of the lease period, subsection 4, the lease shall be put up for auction as per the procedure specified in this act. But there is no question of any further grant of right, mineral rights. And a very dangerous argument was advanced by Mr. Subramaniam that the previous lessee also steps into the shoes of the new lessee, because X was the ex-lessee and X is the present lessee. It is not foreseen, it is not anywhere contained in the act, except two provisions where I will bring to your lordship's notice, section 8B, which is a vesting clause.
No, I couldn't understand this submission. Please repeat it.
I am repeating, Milord. There was an argument in the bar that X, let's suppose the present petitioner, which I will refer to, he was the old lessee and he is also the new lessee. So therefore, he will step into the shoes of the old lessee in the same mining area is fallacious.
There is a question of stepping into.
No, his argument, because he says that this is my mineral. I will explain, Milord, in detail. After 50 years, Milord, 31/3/2020, a lessee loses all the mineral rights in respect of the area, subject, of course, to the exception 12 GG and HH. What right he is, Milord, holding, that is only for the limited purpose of removal of the legally extracted minerals, not beyond it. He neither can carry on any fresh mining operation, nor can excavate. So therefore, Milord, they were contending that it is a vesting. Milord, that vesting clause I will show to you, Lordship. Milord, section 8B.
Not a vesting.
No, Milord, they were contending that since the statutory clearances, other things are vested in the new lessee, so therefore the plant machinery and the mineral, whatever is left in the same leasehold area, would automatically vest in the ex-lessee.
No. This was not the submission.
No, Milord, this was an argument. One of the arguments. He was arguing that I am the ex-lessee, I am the present lessee. So the competent authority has permitted me to use the plants and machineries. So therefore, I am also entitled to the remaining part of the minerals lying over the area. This argument was advanced. I have noted, Milord.
Oh, that.
Sure, I'll answer that. So, Milord, section 8A6. Let me go one by one. So, Milord, 8A6 is a non-obstante clause, which clearly provides, your Lordship may kindly, your Lordship have also, Milord, laid one judgment. I was arguing, incidentally, the force majeure clause. Any other happening beyond the control. That has been interpreted by your Lordship, and also a division bench of the Honorable Karnataka High Court Justice Works judgment, Salimar Milord judgment, which your Lordship have also taken note of in JDL Mines. I'll refer to that little later. But subsection 6 of section 8A is very important. Notwithstanding anything contained in subsection 2, 3, and subsection 4, the period of lease granted before the date of commencement of the Mines and Minerals, so and so Act 2015, where mineral is used for other than captive purposes, shall be extended and be deemed to have been extended up to a period ending on the 31st March 2020, with effect from the date of expiry of the period of renewal last made, or till the completion of renewal period, if any, or for a period of 50 years from the date of grant of such lease, whichever is latter, subject to the condition that all the terms and conditions of the lease have been complied with. This is what the legislative intent is, that leasehold right up to the period of expiry of the lease, which is, Milord, a date 31st March 2020, and not beyond that, and no longer. So the leasehold right, Milord, including the rights to carry on the mineral operations, in consonance with section 4 of the Act, Milord, ceases to exist as soon as the lease period has expired. So no right thereafter. even if somebody has come out successful in the auction, which was held subsequently after expiry of the lease period, he is to be treated as a fresh lessee for all practical purposes, and no right whatsoever which had accrued under the old lessee would ipso facto be vested on the new lessee. Nor, there is no classification at all. The expression previous lessee and the new lessee only finds place, in two provisions of the statute. Section 8B, your lordship may kindly refer to. In this act or any other law for the time being in force. What is to be vested, it is spelled out here. These are the limited things. All valid rights, approvals, clearances, licenses, and the like granted to the lessee in respect of a mine, other than those granted under the provisions of the Atomic Energy so and the rules made thereunder, shall continue to be valid even after the expiry or termination of the lease, and such rights, approvals, clearances, licenses, and the like shall be transferred to and vested. Let's see if I kindly mark this. Shall be transferred to and vested, subject to the conditions provided under such laws in the successful bidder of the mining lease selected through auction under this act. This is the limited things which are vested in the new lessee. The term, it is expressed previous lessee and the new lessee, not old and new. Previous lessee and the new lessee. It is this is more explicitly dealt with in Rule 9A of the 2016 rules. Your Lordship may, for the time being, may kindly turn to 9A of the rules, 2016 rules.
So is this your submission that except for these things?
Right, Millard.
Like clearances, licenses, and granted to the lessee, other things will not vest. These are the only things which...
That's correct. That is subject to GG and HH, operation of law. Otherwise, Millard, had it been the... That is, Millard, the other things are dealt with in GG and HH. 12(1) GG and HH. Well, 6 months plus 1 month.
Again, Mr. Acharya, we will have to understand the purpose of Section 8B. Section 8B says that if in an auction the lease is granted to a new lessee, then the approvals which he was having, the clearances which he was having, the earlier lessee,
right,
and the licenses which he was having,
right,
those shall vest.
Those shall vest.
So that he may start the
immediately.
Exactly.
Exactly.
So that is it makes a provision,
right,
for smooth transition.
Absolutely correct.
That's all. It is not like that right that license vests in the new lessee.
Absolutely, Millard.
So it is not that all other things
will vest. Let's look at it, Millard.
Yes.
So other things will not vest. That is to be dealt with in accordance with 12 GG and HH.
You're right.
Yes. So 9A, Millard, Rule 9A. Rule 9A.
Yes.
Conditions for issuance of vesting order and for obtaining rights, approvals, clearances, licenses, and like under Section 8B of the Act. Rule 2016 rules. This makes the whole thing clear. Yes. Rule 9, capital A.
Just. Yes.
May I read, Millard?
Please.
Conditions for issuance of vesting order and for obtaining rights, approvals, clearances, licenses, and like under Section 8B of the Act, which I read just now. The state government shall nominate a secretary level officer of that state as the nodal officer for the purpose of issuing vesting order for transfer and vesting of all valid rights, approvals, clearances, licenses, and the like in accordance with subsection 1 of Section 8 capital B. The nodal officer nominated under sub-rule 1 shall be authorized to collect all the valid rights, approvals, clearances, licenses and the like vesting with the previous lessee and shall issue vesting order in favor of the new lessee along with the letter of intent. Milord, sub-rule 3, Milord, the vesting order issued under sub-rule 2 shall have the same terms and conditions of every rights, approvals, clearances, licenses and the like which vested with the previous lessee. Milord, it shall be lawful, Milord, sub-rule 5, Milord. It shall be, Milord, the whole thing has been dealt with vividly, Milord. I am showing only 5, sub-rule 5. It shall be lawful for the new lessee to commence and continue mining operations on the land in which mining operations were being carried out by the previous lessee after execution of the lease deed till expiry or termination of the mining lease granted. So it's a fresh lease, Milord, for all practical purposes and for your, Milord, more clarity. For the time being, I may take your lordship to the vesting order. Lord, in one of the cases I have prepared, in fact, that is sub-item number 4, that vesting order your lordship would find in Sirajuddin and Co., which was argued by my Lord Senior Mr. Subramaniam. That vesting order your lordship would find at page 174 of the read petition number 18740, Milord.
Yeah.
Okay.
Which annexure?
Annexure
4.
G12 GGHS kind. Annexure. Got it. Look, this is the vesting order that is in consonance with this 8B2. Milord, may I read? This would make the whole case clear.
Yes.
Milord, whereas a mining lease of the following description, which was held by Messrs. Sirajuddin and Co., a partnership firm hereinafter referred to as the previous lessee, with validity period up to 31/3/2020, has been auctioned, and Messrs. Sirajuddin and Co., a partnership firm, has been declared as the preferred bidder of the said mine. Description of the mining blocks so and so, Milord, and whereas a letter of intent bearing dated 2nd March 2020 has been issued in favor of the preferred bidder for grant of mining lease for the above mentioned mining block. Milord, because after, Milord, much before 31/3/2020, this auction process commenced because the lease period was coming to an end. So before that, they wanted to finish up everything, complete everything. So this was the, Milord, they called it the preferred bidder. Thereafter, this vesting order has been issued in the month of June 2020. That is after, Milord, 31st March. And whereas in terms of section 8B2 of the MMDR Act, read with rule 9A4 of the minerals so rules, the holder of the letter of intent for the said mining block shall be deemed to have acquired all valid rights, approvals, clearances, licenses and the like vested with the previous lessee. Now, therefore, the undersigned being the nodal officer for the state of Odisha, having been nominated under rule 9A1 of the minerals so rules, do hereby, pursuant to the provisions contained in rule 9A2 of the rules, order that all the valid rights, approvals, clearances, licenses and the like vested in the previous lessee in respect of the aforementioned mining block are deemed to have vested in favor of the holder of the letter of intent on the same terms and conditions of every rights, approvals, clearances, licenses which vested with previous lessee. Milord, your lordship may kindly, this vesting order was valid for 2 years. The next page, Milord, your lordship may kindly look at annexure 1 appended to the said A, that is, Milord, without prejudice at the top, Milord, 175. Without prejudice, 175 at the top.
Yes.
Without prejudice to the generality of the provisions of section 8B2 of the MMDR Act, the details of the valid rights, approvals, clearances, licenses and the like held by the previous lessee and vested in favor of the holder of the letter of intent are given in annexure 1 to this order. This annexure 1 is the next page, Mila. 177, annexure 1 appended to the vesting order. Mila, the para 1 is very important. That is the crux of the matter. The next page, 177. I think you will also got it.
Yes, yes.
Para. Vesting of clearance. Mila, this is very important. Vesting of clearance, approvals, licenses, permissions, rights as above doesn't have the effect of transfer of ownership of infrastructure established and the ore and minerals raised by the ex-lessee, which shall be governed by the provisions of 12.1 GG and 12.1 HH of the Mineral Concession Rules 2016. Lord, having accepted this, I don't think, Lord, any argument is open to be advanced by the ex-lessee.
Just.
This is very important.
Mr. Acharya, the situation is not only completely just the reverse. Just the reverse for the reason that when you are relying on 174, when it talks of vesting, then see what is first thing which is vested. Just see what is, come to page 177.
174 million.
Yes, 177 is the vesting.
Minor. 174.
What has vested?
Yes.
What has vested is mentioned in 177.
177. That is, your lordship is correct.
All right.
Yes.
So what is the first thing which we vested? Which vested?
Mining plan.
Mining plan vested.
EC.
EC vested.
Environmental clearance.
Environmental clearance vested.
Right.
FC vested. So these are the clearances. These are the approvals.
Minor.
So for the subsequent lessee, even if he is Y, not X, even if he is Y, he is not required to have fresh mining plan, fresh EC, fresh. So these things are vested. So these are vested, and then now read what you are reading, clause 1. Vesting of clearances, so and so rights above does not have the effect of transfer of ownership.
My lord, absolutely.
Transfer of ownership. So you are thinking, when you are addressing your submission on X and X.
X and
and just think of X and Y. So it does not amount to transfer of what? Transfer of only approvals.
Right,
absolutely. Transfer of only clearances.
Absolutely, Mila.
A vesting of clearances.
Right,
this is the vesting order.
Mila.
So this, and you are right, that based on this only, one cannot claim that all the rights over the thing vested. So that those aspects will have to be addressed in terms of 12 GG, 12 HH. We will see. But this is difficult for you to rely on this, because this has, and then it says absolutely right that shall be governed by the provisions 12.1 GG and 12.1 HH.
That is what
this is crystal clear. It is crystal clear based on this vesting order that what was directed to be vested was the licenses and approvals, those vested in the new licensee, the new lessee, because he holds the license.
Absolutely.
He holds the, he had not applied. He had not applied pressed the mining plan. He had not applied for the environment clearance. But still, because of this vesting order, that stands vested.
Vested. By operation of law, it will vest.
So that stands vested.
Milord, irrespective of whether X becomes X or X becomes Y.
Absolutely right.
That is not the provision.
Absolutely.
It doesn't. Yes.
Absolutely. There is no difference. You are correct, Mr. Acharya. That it is either X or X or Y. What will vest are these which are mentioned in the vesting order from 1 to 8.
1 to 8.
So far other things are concerned,
it will not vest.
No. It doesn't say that. It says that that will be governed by 12(1)
12
GG
GG
and
and
12(1).
HH. Lordship
So
is
this
correct. That is what I'm
Yes.
hinting at, Milan.
Yes.
So, Milan, that is what I'm hinting at. I'm hinting at that by this is the legislative intent that the right, Milan, continues up to the expiry of the lease period and no more. And so as long as it has not been put to auction, Milan,
So
the
that we will
state
see. That we will-
exclusively has the right over the land.
Mr. Acharya, that we will see what will happen to the equipment, what will happen to the ore which was excavated based on the interpretation of 12(1) GG. But when you are referring to 8A and 8B for the purpose of vesting, that is very limited. That is
Exactly what I'm submitting,
context.
Milan. That is exactly what I'm submitting. There is no vesting of the minerals. There is no vesting of the machineries or other things which are dealt with in 12 GG and HH. What is the limited thing which is vesting on a new lessee? Even X becomes X or X becomes Y. These are the limited, Milan, clearances, etc., etc.
All right.
So, Milan, now your Lordship may kindly come to the provision, a few other provisions.
Yes.
That is Section 4, Milan, of the Act. The prospecting or mining operations to be under license or lease, no person shall undertake any reconnaissance, prospecting or mining operations in any area, except under and in accordance with the terms and conditions of a reconnaissance permit or of a prospecting license or of a exploration license, or as the case may be of mining lease, granted under this act and the rules made thereunder. Milord, this is not important. Your Lordship may 1A. No, Milord, 1A. That was, Milord, no person shall transport or store or cause to be transported or store any mineral. Milord, this is what is prohibited. That is to be read with section 23C. Why this concept of intermediate storage? Because, Milord, there cannot be any storage without a valid permission to be granted by the state. I'll show the rules also, Milord. Milord, 1A. No person shall either transport or store or cause to be transported or stored any mineral otherwise than in accordance with the provisions of this act and the rules made thereunder. No mineral concession shall be granted otherwise than in accordance with the provisions of this act and the rules made thereunder. May after so and so, your Lordship may then kindly come to the rule making power 23C, capital C. That is the power of the state government to make rules. That the objective is for preventing illegal mining, transportation, and storage of minerals. That is the heading of the rule, and the appropriate the state government has been authorized to make the frame the rules. The state government by notification in the official gazette make rules for preventing illegal mining, transportation and storage of minerals and for the purposes connected therewith. Milord, we are concerned with Milord, G Milord, small g. This storage has been dealt with also elsewhere in D also, clause D, E, my lord. Any other matter which is required to be or may be prescribed for the purpose of prevention of illegal mining, transportation, and storage of minerals. That's got it. This is by, in exercise of this power, my lord, the state government, my lord, the state of Orissa has framed a set of rules, my lord. They are styled as that this is, my lord, your lordship would find in the local laws. Now, Milord, why this intermediate storage concept came in, Milord? 24 leases were expiring, Milord, on 31/3/2020, Milord. 21 leases, 24 leases. Milord, only 6 parties are litigating since 2020 in the garb of corona disaster, global disaster, force majeure, etc. They have been litigating since last 4 years.
You can't say in the garb of because that is a proved fact, one, and two, this court has taken note of.
But I'll come to that. I'll answer how they are, Milord, how they are playing with this, a clear abuse of the process of the court. I'll come to that. They have been given sufficient time. I'll show, Milord, from records and from previous orders also. Milord, we are in 2024. This so-called COVID pandemic disaster, Milord, the kind of things they are, Milord, making submissions, advancing in 2024, it is no more there. And for your lordship's kind information, I have given a chart.
Mr. We are in 2024.
Yes.
But this writ petition was filed in 2021.
They have been given time. I'll come to that, Milord. I'll come to that. So, Milord, what has happened beyond this statutory period, Milord, period of 31st October 2020, Milord, that is the maximum permissible date before which they are, Milord, required under law to remove the minerals. Because the lease expired on 31st of March 2020, the period of 12/1 GG, Milord, commenced from 1st April 2020, ending with 30th of September 2020. Failure on the part of the lessees, Milord, inevitably compelled the state government to take recourse to 12/1 HH, which period is yet another 1 month. 6 plus 1, 7 months period expired on 31st of October 2020, Milord. They came before this honorable court. Within that period, Milord, the dispatch is maximum by those lessees. Because your lordship knows that none of the government of India circulars, Milord, put any restriction on the transportation and dispatch of minerals. It was exempted. It was not, and during that, Milord, corona period, all those lessees, 6 lessees, Milord, other 18s don't have grievance. They have transported everything. Those, Milord, 6 lessees have been litigating. They came in 2020. Lordships, the earlier division bench gave them a liberty to file a representation, did not consider it as a force majeure. Para 60 of the division judgment is very clear. I'll take your lordship to para 60 of the judgment after this. They say that this force majeure, Milord, event is a matter to be dealt with by the state government. In fact, it is not a force majeure, Milord. Force majeure 12/1 FF, Milord, applies to the conditions enumerated in sub-rules 1A to EE during the currency of the lease period. That is the language of 12/1 FF. COVID pandemic may be a global disaster. None of the government of India's circulars, Milord, restricted the mining operation, transportation, dispatch, etc. And annexure A by 2 to my counter affidavit would amply demonstrate they have made the maximum transportation during this period, because China was, Milord, requiring, and they have sold it 9,000 rupees metric ton, whereas the previous price was 2,500. Because there was a demand by China following Australia's censor. Australia did not, Milord, export any cargo, iron ore cargo. So the steel industries in China were sinking. So therefore, India, especially Orissa, Milord, is the only state which exported maximum cargo, iron ore cargo. They have been enriched, Milord, unjustly. They say that the state is going to be unjustly enriched. Is Milord, quite fallacious. I'll show from records, Milord. I'll come to that. So 12(1) FF is a contingency, my lord. This force majeure clause, which has no application to GG and HH. Your Lordship may kindly, at this juncture, may I take your Lordship to 12(1) FF and the whole rule 12.
Yes, sir. Yes.
Milord, let me finish this 10B, Milord. This storage, intermediate storage, because I may be distracted from this 10B. I'm sorry, Milord. I'm sorry.
Yes.
My apologies. The government may, 10B, capital B. This is, Milord, styled as Orissa minerals, prevention of theft, smuggling. It's a very big rule. Illegal mining and regulation of possession, storage.
Name is big, mister.
It's a big rule.
Rule is not big. PTSI, MRP,
Yes.
STT.
PTSI, MRPS, there are so many alphabets, Milord. They have covered everything. 23, Milord. 10B.
Yes, please.
The government may, by an order in writing, relax the provision of these rules. But the rule says that you cannot store. I read out from section 4 also. There cannot be any storage. There cannot be any transportation, save and except as contemplated under the Act and the rules, except the provisions under the rules. So, my lord, here there is a provision of relaxation by the state government. Therefore, my lord, the government came out with this notification of 4th October 2019, this intermediate storage on the application of the lessees. My lord, none of the lessees, my lord, avail that intermediate storage. Your Lordship may kindly note this.
Yes.
They didn't avail. Rather, they come forward with a plea now that we were not provided with the storage. It is their duty, my lord, to find out space for themselves. It's not the state's duty because...
Petitioner did not avail what?
No, the intermediate storage facility.
Yes.
They assume that the land belongs to us, the mineral belongs to us. We continue to be the absolute owner of everything, whatever is left beyond 31/3/2020. And therefore, my lord, we have a right. They claim it's a fundamental right, my lord. Your Lordship knows it is pure and simple a statutory right. Neither it's a fundamental right nor a common law right. So therefore, my lord, if there are statutory prescriptions and limitations, a lessee, whether ex or new, my lord, is to be governed as per the provisions of the statute and in no other manner. That is what, my lord, is the well-recognized principle in administrative laws while we interpret a particular statute. Whether, my lord, 10B, the government may, by an order in writing, relax the provision of these rules to such extent and subject to such conditions as may be specified in the said order, as it may consider expedient or necessary for facilitating procurement and transportation of minerals and purposes connected therewith. If your Lordship would permit me, if I go to the intermediate storage gazette notification, that says, my lord, the lessees, my lord, they represented to the government. That is way back in October 2009, much before 6 months before the expiry of the lease period in March 2020, government considered their application in relaxation in an invocation of exercise of power under 10B of the rules, provided with an intermediate storage to facilitate the removal of those, my lord, iron ores which they extracted during the currency of the lease. Nothing beyond that. No assurance to hold any lien or right over the property. 12 rule, my lord, rule 12, your Lordship may kindly turn to now.
Rule?
Rule 12.
12.
Rule 12. My lord, before that, if your Lordship would permit me, I may take to the old rules. Let this particular mining lease, there is a format. They are all old lessees prior to the Amendment Act 2015. They were governed by the 1960 rules earlier. After Amendment 2016, my lord. So there is a format called Form K, which is the lease deed, my lord. There is, my lord, paragraph, clause 4, 5, and 6, which is very important of the old rules. and that format is a prescribed format under Rule 31 of the Mineral Concession Rules 1960, which came to be, my lord, repealed with a saving clause. My lord, Rule 31, your lordship may kindly look at 1960 rules.
Rule?
Rule 31, C1 of the Mineral Concession Rules 1960, because they are to be governed by this, and the lease deed is in the Form K, format Form K.
You are referring to Odisha,
No, my lord, Mineral Concession Rules 1960, my lord. My lord, prior to, after the amendment, this 2016 rule was framed. So prior to that, the governing rule was MC Rules 1960.
Yes.
Applicable rule was 1960.
Yes.
Lease to be executed within 6 months, where on an application
Where
for
are reading?
my lord, Mineral Concession Rules, Rule
No, which
31.
part of that?
My lord, that is also in this book, my lord.
No, Form K.
Form K. I'm reading Rule 31 and then
31.
Form K.
All right.
Then Form K, which is appended to this rules also.
Yes.
My lord, that is on a record. Annexure, they have given the previous list, where on an application for the grant of mining lease.
Yes.
My lord, may I start, my lord? Where on an application for the grant of a mining lease, an order has been made for the grant of such lease, a lease deed in Form K or in a form as near thereto as circumstances of each case may require, shall be executed within 6 months of the order or within such further period as the state government may allow in this behalf. Your lordship may kindly turn to Form K, which is the lease deed executed between the government and all those 6 petitioners. My lord, that your lordship would find at page 125. If your lordship is holding this book, that would be 125.
Yes.
Let's see. My lord, I am taking your lordship to part 9. Just a minute. General provisions.
125.
My lord, part 9.
Form K, I am there.
Form K begins at, my lord, 125.
Yes.
My lord, I think I am holding the
All
same
right,
book.
all
Same
right.
book.
Yes.
Your lordship may kindly turn to 139. Page 139.
Yes, part 9.
General provisions. Lord, these are the terms of the lease. Lord, we are concerned with para 4, 5, and 6 or clause 4, 5, 6, whatever is convenient. Failure to fulfill terms of lease due to force majeure.
Part 9.
Minor.
You are referring to what?
Lord, force majeure. Lord, this is the condition which is embodied in their lease deed. And we executed a supplementary. Yes.
Yeah.
Failure to fulfill terms of lease due to force majeure. The terms of lease is the currency of the lease. That is the word which has been, that is the word particular thing, Lord, currency of the lease. The lease means, Lord, a subsisting lease. Failure on the part of the lessees to fulfill any of the terms and conditions of this lease. Lord, after 31/3/20, he becomes a previous lessee. Lessee obviously refers to a leasehold, a lessee who is holding a license to carry out mining operation, not beyond 31/3/2020. 31/3/2020, he becomes a previous lessee on 1st April 2020. So failure of the part of the lessee to fulfill any of the terms and conditions of this lease shall not give the central or the state government any claim against the lessees or be deemed to breach of this lease, insofar as the failure is concerned by the said government to arise from force majeure, and if through force majeure the fulfillment by the lessees of any of the terms and conditions
So
of
according
this.
to you, the
Yes.
moment the lease expires, the word lessee is not to be used for
the new lessees.
No, not for the new lessees, who is no more a lessee.
Who is no more a lessee?
Your submission is
my lord,
that if the lease of a lessee expires on 31/10/2021,
31
then-
pre-20 million.
20, then wheresoever the word lessee occurs, that shall not be referred to the one who was earlier a lessee.
Absolutely correct, my lord. That is what the position of law. They can't wriggle out of it. Phrase or new, it makes no difference.
No question of fresh only. If
force majeure, Miller,
yes,
is applicable to a lessee whose lease is subsisting, not beyond it.
Therefore, if we read this provision with your interpretation,
that is to be read along with the previous conditions of the lease. It would make things more clear if we go to Rule 12 of the new rules, because they are bound by the new rules.
Yes.
Because of execution of this supplementary list after the commencement of the Act. Because the period of 50 years extended by virtue of Section 8A6 and 8.4.
So you can say at least that he was a lessee.
He was a lessee. He was a lessee.
But you cannot say that the expression lessee cannot be used at all for...
No, the force majeure clause. So far the force majeure is concerned.
Force majeure clause, if the force majeure happens during the concurrence...
Currency of the lease.
During the currency of the lease. Then what will happen?
And that would happen, Millard, the consequences will follow. Suppose, Millard, the consequences will follow. He may, Millard, that is spelled out. Let me read further.
Yes.
Let me read further. What is also, Millard, what are the conditions? That is important.
Yes.
Millard, in none of them, I may repeat, Millard, in none of the Supreme Court judgments also, in Chugle 1, Chugle 2, Goa Foundation, and also the previous division bench judgment on which they are harping, they have said that corona is a force majeure. Nowhere, let them at least find out one judgment which says that corona pandemic was a force majeure event. Nowhere. That I respectfully submit. I'll come to Chugle 1, Chugle 2. I'll come in which circumstances the time was granted. Your lordship is right. It is under 142, maybe. But there can't be a mandamus against law. They are seeking issuance of a mandamus against what the statute says. They want to enlarge the scope of GG and HH. And Millard intends to bring out the force majeure clause, 12(1) FF, after the expiry of the lease. That is what I am hinting at, Millard. That is what I am submitting, my humble submission. Your lordship may read below. Millard, what would happen? For feature of the property. Millard, your lordship may look at the language here in the old form K.
Yes.
This is what the Millard legislative intent is. It is clearly spelled out.
Yes, please.
Let the heading. Lessee, Millard, let's say force majeure. I was paused here, Millard.
Yes.
Insofar as failure is considered by the said government to arise from force majeure, and if through force majeure the fulfillment by the lessees of any of the terms and conditions of these leases be delayed, let's mark this, these leases be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, the expression force majeure means an act of God, war, insurrection, riot, civil commotion, strike, earthquake, tide, storm, tidal wave, flood, lightning, explosion, fire, earthquake. And Millard, with great respect, I was trying to interpret, Millard, this any other happening which the lessees would not reasonably prevent or control. Your lordship repelled it by taking recourse to 8A6 and following R.P. Sawa judgment by Chief Justice Javeri and also the Salimar by Justice Oak, a Karnataka division bench judgment. I'll place these three judgments also, Millard. So therefore, this corona pandemic, which may be a global disaster, two submissions I have. First of all, there was no restriction. Mining operations were squarely, Millard, kept out of the purview. So far, this period is concerned. All those lessees, Millard, have exported and have dispatched, Millard, maximum metric tons of minerals during this period, Millard. 6 months period, I've given a figure in the shape of financial A by 2. So the plea that we could
Please see the next.
next, my lord, lessee to remove their properties on the expiry of lease. My lord, that is the period of 6 months, 12 GG.
So therefore, for 6 months, he is a lessee.
He is not a lessee, my lord, exactly.
Therefore, why
He is holding a right of for the limited purpose.
Maybe, but according to we, in fact, I was also ready to accept your submission that the lessee is not to be treated as a lessee, but that expression has not to be used the moment the term of lease expires.
No, my lord, I will take your lordship to auction rules also.
Please come to this.
Yes. The lessee lessees, having first paid discharged rents, rates, and royalties payable by virtue of this
No, see, it says
Lessee
lessees to remove their properties on expiry of lease.
My
So
lord.
on expiry of lease, the lessees can remove their properties.
See,
So it
those
is not-
lessees, my lord.
Therefore, when
My
you
lord,
are saying
an argument, my lord, I'm pausing for a moment. My lord, Mr. Salve was appearing for a new lessee. In KJ Salwalia case where Mr. Rotugi was, my lord, that argument has been dealt with. He was arguing, my lord, that I being the new lessee, in respect of the leasehold area, I have accrued all rights which the previous lessee was enjoying. So I am the owner of the minerals. So that was repelled. That was repelled. So
that was obnoxious.
So therefore, my lord, it doesn't, my lord, carve out any exception. That has been dealt with in the division bench judgment. So therefore, if the new lessee cannot acquire that right, new lessee after the auction, my lord, certainly the previous lessee who is incidentally becoming the new lessee can't have that right.
No.
On the
See,
same analogy.
We are not confining to XX. We are considering these aspects generally.
My lord.
Whether it is XX or XY,
Why?
there may be the three of the circumstances which are there before us.
Right.
So, in fact, what we understood from your submission, that whenever the word expression lessee is referred to under the rules, or that means the lessee during the period of lease,
Right.
not otherwise.
No, my lord, that is not my, my lord, my submission is, my lord, let me be not misunderstood for. He may be a lessee, but that lessee's right is limited, circumscribed by the statutory provisions.
That is what is being said, that till the lease subsists, then he is a lessee.
He is a lessee. So beyond that period, what right he is to enjoy, that has been spelled out here.
Exactly.
Para 5, 6 read with GG and HH.
Right.
So, my lord, 5 is GG, 12.1 GG. 4 is 12.1 FA. And my lord, 6 is 12.1 GG. My lord, I will take your lordship to the new provision. My lord, para 6, my lord, for feature of property left more than 6 months after determination of lease.
Yes.
Let's see. If at the end of 6 calendar months, after the expiration or sooner determination, let a lease can also be determined. There the period is 3 months to 6 months.
Yes.
Of the said term, under the provision contained in clause 4 of part 8 of the schedule, become effective, there shall remain in or upon the said land any ore or mineral, engines, machinery, plant, buildings, structures, tramways, railways, and other work, erections, and conveniences, or other property which are not required by the lessees in connection with operations in any other lands held by them under prospecting license or mining lease. The same shall, if not removed by the lessees within 1 calendar month after notice in writing, requiring their removal has been given to the lessees by the state government, be deemed to become the property of the state government and may be sold or disposed of in such manner as the state government shall deem fit, without liability to pay any compensation or to account to the lessees in the respect thereof. There is a clear forfeiture. It is deemed to the property of the government.
Yes.
No right after 7 months. That is, Milord, is the legislative policy. That is exactly what also argued by them. All through, Milord, if I pause here for a moment, consciously, knowing fully well about their rights and liabilities under law, they have represented for extension of time, both in the previous writ petition and in the representation, and also the execution of the lease deed in July 2020, this particular Milord petitioner, which I am holding now, Sirajuddin. Not only that, Milord, there is a minimum guarantee production criteria, minimum production guarantee criteria. 13,000 crores have been, Milord, demanded against this particular petitioner, and he is litigating. 2 other writ petitions are pending. 13,000 crores. For non-fulfillment, there is a demand.
Acharya, amount is immaterial for us. Maybe 3,000 or 13,000 crores.
I am Milord, only. No, it's not, Milord. I am not. The conduct of a party is also to be just in a 226 proceeding.
You are right.
Your Lordship, conduct of a party is an important factor in a 226 proceeding.
Yes, Mr.
Whether he has come to the court with a clean hand, whether he is abusing the process of the court.
Did you challenge the decision of this court?
It was not necessary. We disposed of. They gone to Supreme Court last.
Yes.
You know, some of the petitioners, I will find out the order.
All right.
I'll find out. It is on record. I'll find out. Lord, in this second also, I'll show one order. Let me, Lord, at this juncture, should I point out one order? One order of this court. That is of 10th October 2021.
No, for what?
For the purpose that they were granted time till December, 15th of December 21. That's it, may kindly look at. With the consent of they say, argue a different, Milord, advance a different argument now. That we are the way. Your Lordship may kindly see the last order. Last order of this, Milord, this order.
That 1 month's time or which one? That 1 month?
1 month to 12 HS they were granted after disposal. Milord, 5th of May 21 representations were disposed of. 24/5/21, we issued the 12/1 HS again for availing 1 month. There they got 1 month. Being dissatisfied, they waited till 24/6, did not avail that opportunity, came before this court, said that this rejection, impugned order of rejection is bad. This is arbitrary. But how they are playing, Your Lordship? They were given 1 month. 24/5/21.
They filed which writ application?
The present one?
Yes, all that has been because
No, didn't avail that benefit of 1 month also.
that was 12/1 HH.
12/1 HH. They come here and say that we still require time. So, Milord, this order, Milord, Your Lordship may kindly look at here. 29/10/2011, 21. After hearing, Law and Counsel for the parties, the following interim arrangement as agreed upon by the parties. Lordship may kindly mark, as agreed upon by the parties.
This is an interim order.
This is an interim order. Is directed to be implemented. The petitioner will, on or before 8th of November 21, apply to the authorities for issuance of transit passes for removal of the mine stock pertaining to the lease period which expired on 31st March 2020. The above application shall be processed by the authorities and transit passes shall be issued in accordance with law on or before 15th November 21 for a period of 1 month thereafter. That is up to 15th December 21 or a corresponding later date 1 month from the actual date of the issuance of the transit passes. The petitioner will be permitted to remove whatever stock they are able to remove, in terms of section 12(1) HS of the minerals, other than those, etc. It is clarified that the responsibility and liability, if any, in this regard, will be of the erstwhile lessee. But here they say erstwhile lessee, with no liability attaching to the present lessee. The question as to what should happen to the remaining unremoved stock as on 15th December 21 or the latter date as indicated in Roman 2 above will be decided by this court while hearing the writ petition. We are in 24 after 3 years. So therefore, which is the state's property now. So not that they were not given time. They were given time 12(1) HH 1 month on 24/5/21 after rejection of the representation. and again time till December 2021, Millard, to facilitate them against the law also. With great respect, Millard, I may say, this interim arrangement was also against the purport of 12(1) GG and HH. Clearly, Millard, clearly.
Yes.
Clearly.
Yes, Mr. Attorney, please.
Millard, now your lordship may kindly turn to 12(1). 12, the whole rule 12. MC rules 2016.
12(1).
Millard, the whole rule 12 of 2016 rule,
yes,
deals with the terms and conditions of a mining ledge. It is clear, Millard, it is in a very crystallized form rather. Everything has been embodied in the new rule 12.
Yes.
Millard, what are the conditions that has been spelled out? Terms and conditions of a mining lease. Every mining lease shall be subject to the following conditions. Millard, the conditions are spelled out. Millard, what are the, that is from the whole entire rule, Millard. That spreads up to leases shall keep accurate, etc., etc. The whole rule, Millard, yeah, I don't want to buy your lordship's time by reading this entire rule.
Yes.
All the conditions are spelled here. Your lordship may kindly, the last condition is E.
Yes.
Yes, you've got it.
Yes, please.
If the lessee, the last Millard condition is embodied in clause W. If the lessee fails to carry out or perform any of its obligations hereunder or under the lease deed within the time specified in that behalf, the state government may cause the same to be carried out or performed, and the lessee shall pay the state government on demand all expenses incurred in this regard by the state government, and the decision of the state government as to such expenses shall be final. This is the last clause. Your lordship may this force measure. Failure on the part of the lessee to fulfill any of the terms and conditions of the act and rules made thereunder, or under the mining lease, shall not give the central government or the state government any claim against the lessee, or be deemed a breach of the lease, insofar as such failure is considered by the relevant government to arise from force measure. In the event of any delay by the lessee to fulfill any of the terms and conditions of the act and the rules made thereunder, or under the mining lease, on account of a force majeure event, the period of such delay shall be added to the period fixed by these rules or the mining lease. Let's got it. So therefore, in this clause, the next, in this clause, the expression force majeure means an act of God, etc., etc., and any other happening which the lessee could not reasonably prevent or control. Your lordship read down this rule in conjecture with section 8A6 in the JDL Mines case. I was advancing this dangerous argument that a thing which is beyond the lessee's control, so that period should be excluded from the total period of lease. So I should be extended that period, which was rejected in RP's house case earlier by Chief Justice Javeri's bench, which your lordship also took note of, and also the Salimar case of Karnataka High Court. But I'll take your lordship to these three judgments little later. So, but this Millard force majeure obviously refers to the lease Millard, and the breach of any of the conditions spelled out in 1A to 1EE, and this would be applicable not to a stage after the expiry or termination of the lease, which is to be dealt with in accordance with 12(1) GG and 12(1) HH. That's my humble submission. Your lordship may kindly note this. Blood HH, GG. The lessee may, after paying the rates and royalties payable under the act and the rules made thereunder, or under the lease deed at the expiry or sooner termination of the lease term, or within 6 calendar months thereafter, unless the lease is terminated for a default of the lessee, and in that case, at any time not less than 3 calendar months, nor more than 6 calendar months after such termination, take down and remove for its own benefit all or any of the mineral excavated during the currency of the lease. During the currency of the lease, engines, machinery, plant, buildings, structures, tramways, railways, and other works, erections, conveniences, which may have been erected, set up or placed by the lessee in or upon the leasehold lands, and which the lessee is not bound to deliver to the state government, or which the state government doesn't desire to purchase. Let's see if I kindly look at the language. So if it doesn't require it, or the state government doesn't intend to purchase it.
Purchase.
They say this what the state government doesn't desire to purchase.
Purchase means that the ownership is someone else.
Someone else.
And if
So-
the government does not desire to purchase, then
Up to 6 months, Milord, we don't dispute.
Yes.
Well, up to 6 months, the period is up to 6 months.
yes.
So what he will do, he has to remove.
Right.
Unless suppose we want, we may purchase it from him during this period. But what is the duty cast upon the ex-lessee is that it is his duty to remove everything.
Right.
So if at the end of 6 calendar months, after the expiry or sooner termination of the lease term, there shall remain in or upon the leased land, any ore or mineral, engines, this same thing has been reproduced, Milord. Erections, convenience, or other property, which are not required by the lessee in connection with operations in any other lands held by it. Any other lands held by it. Under prospecting license or mining lease, the same shall, if not removed by the lessee within 1 calendar month of being notified to do so by the state government, be deemed to become the property of the state government and may be sold or disposed of in such manner as the state government shall deem fit, without liability to pay any compensation or to account to the lessee in respect thereof. But the language is very clear, unambiguous, and is not very eloquently worded that this shall be deemed to be the property of the state government by a legal fiction. So therefore, the lessees cannot and would not have advanced an argument that we still hold lien over the property, rights over the property, and the state should have considered the force majeure aspect, which has not been dealt with in any of the cases. And they have also in fact been given time, notwithstanding the fact that mining operations were exempted during the corona period. And they have, Milord, on record to repeat, Milord, this submission, maximum dispatch and transportation have been made by all those petitioners. That is on record.
Yes.
So, Milord, your Lordship may now turn to, I have prepared a small date chart, Milord, for the chronological events. That this would make everything clear. Milord, one of the writ petitions I am referring to for brevity, because that would be there, the two things are covered, both the previous lessee and the new lessee.
Yes.
And the argument is common in all the case, force majeure. Petitioner was granted, Milord, 17/11/60, was granted iron ore mining lease at Balda block, iron ore mine situated in village Balda, Kalimati and Noyagad in Champua subdivision in Keonjhar district in Odisha over an area of 335 hectares. The lease was valid up to 2nd December 97. Then, Milord, the first renewal. In 99, the second renewal. And 12/1/15, the Mineral Development Amendment Act was promulgated, extending the lease period for non-captive mines up to 31/3/20. 27/4/2015, accordingly, the state government, consequent to the promulgation of MMDR Act, extended the mining leases of the petitioner along with 24 others up to 31/3/2025, Government of Odisha letter number so and so, 1/12/2017, the petitioner executed a supplementary lease deed with the state government, extending the lease up to 31/3/20 in terms of section 8A6 of the MMDR Act. That, my lord, this supplementary lease deed, take kindly, I'm getting disturbed, please. To facilitate smooth transition of mines expiring on 31/3/2020 for removing the mineral and machineries lying in the area before expiry of the period allowed as per law, the state government allowed for establishment of intermediary storage depot by merchant mining lessees whose leases were expiring on 31/3/2020 under Rule 10B of the Odisha Minerals so Storage Rules Trading Transport Rules 2017. Under Rule 12(1)GG of the Mineral Concession Rules, the leaseholders were mandated to remove all or any ore mineral excavated during the currency of the lease, engines, etc., set up or placed by the expiry, that is 6 months from the expiry of the lease. So 6/12/19, the state government issued a notice inviting tender for auction of mining lease of Balda iron ore mines, which was due to expire on 31/3/20 in terms of the Mineral Auction Rules 2015. 2nd of March 2020, the petitioner was declared as the preferred bidder for the Balda iron ore mines and was granted a letter of intent on 2nd of March 2020 at page 169 to 33. This is the which I read out just now. 24/3/20, in response to COVID-19, the National Executive Authority under the Disaster Management Act 2005, Ministry of Home Affairs, issued guidelines to the Government of India and Government of States and Union Territories. But this is very important. Coal and mineral production, transportation, supply of explosives and activities incidental to mining operations were exempted from the lockdowns imposed by the Ministry of Home Affairs on 24/3/2020. This is very important. This was exempted. So, and below 31/3/20, your lordship may kindly I have given the period. And this is especially the corona period.
Yes.
The petitioner's mining lease for the Balda iron ore mines expired 31/3/20. In terms of Rule 12(1)GG of MCR Rules 2016, the petitioner had 6 months to remove all or any of the ore mineral excavated during the currency of the lease. That is from 1st April 20 to 30th September 2020. That month and year quantity dispatched in metric ton, your lordship may kindly look at. April 20, which is the peak corona, because 25th March was the lockdown was declared in nationwide. Your lordship may kindly look at April 20, he has dispatched 1,16,134 metric tons.
From where this you have got this figure?
Milord, this is the figure which we have given, Milord. It is in our book. If you lordship, in our Milord, the dispatch register, because the form I is to be issued by the deputy director.
Because you are mentioning in your written notes of argument, therefore we wanted to know whether.
Milord, we have given this annexed A/2. A/2. I think
so. Can we have, if since you are giving the figures also,
Milord,
can we know what was the quantity dispatched in April 2019?
2019. That we can get the figure, Milord. If your lordship, I can file an additional affidavit.
No, we will not see. If required, of course, we may direct. But because you are saying that in April they had dispatched so much of the ore, 1,60,000. So if this is more than the dispatch in April 1990, then they can't have any case. If the dispatch is substantially less than April 2019, then they may have a case.
No, that is not. They say that we didn't have any opportunity of transporting. All of them, Milord, 18 lessees could remove everything except the 6.
Maybe right. We are not saying that. Either we don't rely on this figure, or if we rely on this figure, we are duty bound to compare it with some other figure.
No, that's correct. But that is inconsequential. Milord, it is basically for the limited purpose of demonstrating before your lordship.
Right. That was, in fact, that was the order of this court for the department to consider.
That's correct. That's
all right. And in that background, the secretary passed the order. Secretary referred to, the secretary has compared the performance of these persons and other persons. Now you are saying that in these months, this was the total quantity dispatched.
Milord, I am coming below.
If we have to
Milord, this
consider
is April, I am coming below. Your Lordship, kindly look at the figure. July 25,48,567 metric tons, highest.
Mr. See, if you are saying this, then you will have to tell us what was in July 2019.
No, that is not July 2019. His lease period had not expired. Lordship may kindly mark. These are the period during which his lease was not in subsistence. He was removing only the extracted minerals because he cannot carry on any mining operation beyond 1st of April 2020.
You are absolutely right.
So this is from the deposited stocks.
On the basis of these figures,
My lord,
how can we record, if we have to record in your favor, that they had been dispatching and there was no effect of the force measure?
That is for this purpose.
Then we will have to compare also, no?
No,
with some figure.
We have to compare because this was the time of COVID. So was there a difference between the quantity removed by him during COVID period and before the previous period? That is why we are asking.
I am explaining.
No, we want the figures.
I am grateful. I am grateful. I am explaining that. Lord, there is a requirement of minimum guarantee, Milord. If he doesn't fulfill, that is section 4B. Then, Milord, 80% of the total volume he has to produce. He has to excavate. So therefore, the volume may be much more during the currency of the lease. Otherwise, there is a penalty clause, which I was submitting because of non-fulfillment of that. Milord, 4B, may I read, Milord? 4B.
No,
because that the volume may be much more. I am not. I am only concerned.
So this is your submission that they could dispatch this much of after Corona. And before Corona, the dispatch must have been much more. Because that was during the currency of
the lease, and there is a minimum guarantee, Milord, for production and dispatch. Otherwise, that is visited with penalty under 4B, and they have been also penalized for that. And Milord, that has also the consequence of termination of the lease if they fail to meet that minimum requirement within 2 years.
Do you mean to say that they could have transported more, but they have not done it deliberately?
Deliberately.
How does it help them?
How does it, Milord, help them?
If they
Milord,
don't
it is their
transport
duty.
materials.
It is not the duty of the state.
You are saying that because they are required to transport during the earlier period, they have done it, but now they did not. That's why, did they have the choice that they could have transported more, but they didn't do it deliberately?
Whatever is left, Milord, that is the state's. It is public property.
No.
Whatever is left, they can't have any claim. It's state's property.
No. What benefit they were deriving or they derived by not dispatching?
Milord, it is huge quantity. They have kept it. They have kept it only for the purpose of, Milord, waiting that the price may go off. It was 2,500. Suddenly it became 9,000 during Corona. So they started, Milord, they Milord, intended to fetch more money.
So if they would have transported more, they would have got more money.
Milord, because again, so that is why, Milord, they came to the court that Corona affected us. It's a global disaster. It's a national disaster. We should be given concession. We should be given time.
We are trying to understand, Mr. Yes, please.
June 20, Milord, 3,61,000 metric ton. July, 5,48,000 metric ton.
Yes.
August, 4,09,000 metric ton. September 2060, 2,60,000 metric ton.
Yes.
Milord, where is I fail to understand. If somebody has deposited a vast quantity and that is also spreading over the area, let's suppose the new lessees, because they can't also meet the minimum requirement, that may entail now penalty for them.
All right.
So vesting order, Milord, which I was referring to, was issued in favor of the petitioner in terms of section 8B of the MMDR Act. With a rider, the vesting clearance does not include the transfer of ownership of infrastructure established, the ores and minerals raised by the ex-lessee, which shall be governed by the provisions of Rules 12.1, GG and HH.
Yes.
Milord, this is important. 8/7/20, that is after about expiry of 4 months, this lease deed was executed between the state of Orissa and the petitioner, the ex-lessee.
Yes.
So it is not a lease in continuity. Your Lordship may kindly mark. This is not a lease in continuity. This is a fresh lease deed, and the period of 50 years commences from this date.
Yes.
May I repeat my submission? This is a fresh deed, lease deed, which was executed afresh between the government of Orissa and the lessee, who is the auction purchaser, for a period of 50 years, and the effective date of commencement of the lease period is 8th of July, not 1st of April 2020.
So when had the lease expired?
31st March 20. In all those cases, Milord, 31st March 20, except one case where the May was the last date. May 20 was the last date, 50 years.
So,
so from 1st April 20.
Why was the gap? From
gap, Milord, it is auction.
It was auction after
It was auction after the expiry of the lease.
Are you sure?
Maybe, Milord, that is the procedure. It goes on. It goes on.
No, because
the letter of intent would be issued. He has to express his intent. In some of the cases, the also auction purchasers didn't, Milord, take it. It was therefore given to some PSUs. Milord, it is not mandatory. Once a preferred bidder, he has put a bid.
All right.
He may turn up, he may not turn up. So in some of the cases also, the bidders, Milord, preferred bidders didn't come up. We had to settle it with the PSUs.
Yes.
So, Milord, this is the gap period. It's a fresh lease.
Yes.
Fresh mining lease deed was executed by the state with the petitioner for Balda block for a period of 50 years from the date of execution of the lease deed in the prescribed format as per Schedule 7 of the MC Rules 2016. That is under this Rule 12, Milord. This format has been prescribed. Like the Form K, old Form K. 10/7/20. Milord, this is very important. This date, your Lordship may kindly mark, after execution of the lease deed, he makes a representation, Milord, contrary to his earlier request in July 29 for intermediate storage. Lordship got it, Milord. Because look at how they are playing hide and seek with the government. So they have come off in October 2019, praying that give us some storage facility. So in July, they become more wiser. In December, they become more wiser when they come to the court that 6 months we should be granted, Corona is the disaster, etc. So thereafter, they say that we are the owner of those minerals. Look at the, Milord, I'll show from their representations and also the prayer. Milord, one moment, your Lordship may kindly turn to the prayer in the fourth item. Prayer, Milord. The same thing, Milord, in stereotype manner, all those 6 petitions have been drafted. Maybe from, I don't know, the same thing, Milord, copy paste.
Well, this is what has been done by the secretary also.
The secretary, Milord, no, the subsequent order is not so. So, Milord, for stereotype petition, stereotype orders have to be passed. So, your Lordship knows. They have taken the same plea and prayer. Milord, if the contentions are the same, the order is bound to be same. I don't know how he has to disagree and deal with it. Milord, prayer, Milord, prayer number 5. In the old petition, new petition. I am showing from the old petition and the new petition. The old petition, Milord, the prayer is for extension of time for 6 months. The new petition also, the prayer is same, prayer number 5, extension of 6 months time. Every time in 2020, they pray 6 months. In 2021, they pray 6 months. And they say that Chugle, Supreme Court granted 6 months time to Mid-East in Goa Foundation. Oh, common cause case is different, your Lordship knows. Those were illegal mining. In Goa Foundation, they say after, Milord, 15th of March 2018, there cannot be any mining. They came. most of the minerals were kept in the jetty for being loaded in the ship. They came before the court, 6 months was granted, time was granted. That was on a different context, also the Mid-East one-line order. So there was no force majeure discussion. Rather, Shalimar Karnataka division bench judgment and your lordship, this division bench by your lordship's judgment in JDF mind. This force majeure has been explained, and that can certainly 12(1) FF, I submitted, it relates to the currency of the lease and violation of 1A to W, and GGHS are to be independently interpreted, bereft of that. And it can't, override the substantive provision incorporated in subsection 6 of section 8A. Maximum period is. No, I was arguing any other happening. They say, because force majeure conditions are stipulated. What is force majeure? It is very same, division bench judgment of this court in the case of very same Sirajuddin. The force majeure has been very eloquently defined, 1969 Orissa, a division bench judgment. I'll come to the decisions a little later. Let me just advance my submissions with reference to the statute and the relevant dates. I'll come to the decisions a little later. They are, essentially praying for a mandamus against law. 12 GG and HS, cannot be interpreted in any other way. After the expiry of the lease, they have no right, save and accept the rights crystallized in GG and HH, independent of FF.
Can GG be read after HH?
After HH.
Can GG be read after, FF be read after HH?
No. No, Milord. No, Milord. With great respect, no. Certainly no.
Just read HH, FF after HH. All right, please complete your submissions.
I'll come to that. If any doubt, Milord, I'll answer. I'm bound to answer. I'll answer. Milord, I was referring to the date chart. 8/7, Milord, 10/7, the representation comes after the execution of the lease deed. All those things happened. April transported, May also minerals transported, June also transported, July whole month 5 lakh some odd quantity transported. Now, Milord, the petitioner becomes wiser. That kindly invoke 12(1) FF. And lockdown, your lordship remembers, on 21st of May 2020, the lockdown was also lifted from the nation. The normal life, Milord, resumed, except the subsequent Omega-2 and all. That is 1 year later. So, Milord, by virtue of the representation dated 10/7/20, the petitioner requested the state government to invoke the provision of force majeure in terms of Rule 12(1) FF of MCR 2016, expressing the difficulties in disposal of available stock in Balda Block iron ore mines in Keonjhar district, and prayed for 6 months extension for disposal of the minerals. But this is what his prayer was in the representation. He says, it is my mineral, I become the owner after this becoming the new lessee. But his prayer, soon after the execution of the fresh listed in July 8th of 2 days before that, he makes a representation for invocation of 12(1) FF. So, there comes the next date, 39/20. The period of 6 months, as contemplated under Rule 12(1) GG of the said rules, came to an end with respect to the petitioner's lease. This GG period was over, 39/20. The petitioner failed to remove the stacked mineral and the machineries. The petitioner, being well aware of its position under law, did not act upon dispatching the mineral lying at its leasehold over within the period of 6 months. Other similarly situated lessees from the same reason have been able to dispatch their stock effectively. Look at the intention. 18 lessees, I repeat, out of 24 whose leases expired, they successfully removed, complied with the statute. At the end of 1/10/20, at the end of 6 calendar months, after the expiry of the lease period, on 31/3/20, the state government in the Steel and Mines Department invoked the provision of Rule 12(1)HH and issued a notice to the erstwhile leaseholders for removal of remaining minerals, infrastructure, erections, and convenience within 1 calendar month from the date of issuance of such notice, failing which, within that period, the remaining properties would be deemed to become the property of the state government. This was the alert. So, my lord, this again 1 month was given. My lord, 110, that period was expiring. My lord, your lordship, on 9/10, what they did? State government rejected the representation of the petitioner dated 10/7/2020, my lord, and directed it to comply with the notice dated 1/10/20 under Rule 12(1)HS of the MC rules. The petitioner filed a writ petition 1910 bearing WPC number 28141 of seeking passing of the notice dated 1/10/2020. The earlier 12(1)HS notice, they came forward before this court to ask 1/10/20. The subsequent is of 21. So 1 month period, instead of availing that, they came after the expiry of 19 days that no, here is an infirmity, you can't invoke this 12(1)HS without considering 12(1)FF. 22/20, this honorable court, while partly allowing the said writ petition, by their judgment dated 20/12/2020, remanded the matter back to the Principal Secretary, Steel and Mines, consider the representation of the petitioner, and decide the representations by a separate speaking and written order after providing an opportunity of hearing to the petitioners. The honorable court categorically observed parties shall abide by the final outcome of their representations to be decided by the competent authority afresh. The court also observed this. That would depend upon the final outcome of the and they were given 45 days time also, my lord, in some cases. Here status quo was directed to be maintained till the disposal for a period of 45 days to be but by the afresh. The honorable court, however, did not decide the application of force measure and left it open for reconsideration by the, this is important, my lord, para 60 of the judgment.
Yes.
But I have quoted it here also. This court does not deem it appropriate to discuss in detail on the aspect of applicability of force measure clause due to COVID-19 reasons in the case of the petitioners, as in our view, this matter should be left for the reconsideration by the competent authorities of the state. We have dealt with it, how the 12(1)FF doesn't apply to a scenario, to a situation after the expiry of the period, of the lease period. 77 is also, my lord, that is the direction part, directive part of the court. We therefore, while partly allowing so and so liberty to place all such materials, this is which are last, my lord, the direction page para 77 of the report judgment, which shall abide by the final outcome of their representations to be decided by the competent authority.
Yes.
Here also the subsistence of their lease period. It is directed that till disposal of the representations suppressed by the competent authority, status quo with regard to minerals excavated by the old lessees during the subsistence of their lease period, the plants and machineries, etc., lying in the respective leasehold areas shall be maintained by the parties, which shall abide by the final outcome of their representations to be decided by the competent authority afresh. 29/12/2020. They made a representation after the disposal. The petitioner made a representation to the state government seeking an extension of time under Rule 12(1)GG, following were the petitioner's primary contentions. These are the principal contentions in the representation. Petitioner was the ex-lessee as well as the new lessee for the Balda. I don't know mines, therefore Rule 12(1)GG/HS have no application to a continuing lease. Therefore, I was, Lord, making a submission before your lordship. It is not a continuing lease.
Yes.
8/7/20, my lord, the fresh lease deed amounts to execution of a fresh, my lord, that confers a status of a fresh new lessee. And the term of the lease period is 50 years, which commences from the date of execution of the lease deed. That doesn't include the period which has elapsed after the expiry of the lease. There is a gap. So the second contention, the petitioner being the continuing lessee was entitled to extension till 31/3/2022 to remove material in terms of notification dated 4/10/2019. The petitioner was entitled to extension of the time period under 12(1) GG on account of force majeure conditions as a result of lockdown imposed so that the petitioner pandemic and capping of vehicles for transportation by the state government. Petitioner was prevented from disposing its excavated iron ore, including low grade and soft grade ores with ferrous content below 60 to 62% on account of lack of permission for stacking and sampling, which was required for dispatch of low grade. Not correct, Miller. The state government granted an opportunity of hearing to the petitioner as per judgment dated 22/12/2020 of this Honorable Court for consideration of the representation dated 29/12/2020. Accordingly, the learned advocate representing the petitioner appeared before the authorities on 2nd of February 21 and submitted a written submission by virtue of a well-reasoned order. This order, Millard, they impugn in the present batch of petitions. Speaking order, the state government considered the submissions of the petitioner and disposed of its representation by order dated 29/12/2020 by rejecting the contentions of the petitioner. The petitioner was directed to remove the balance votes, plant and machinery lying in the leasehold area in accordance with Rule 12(1) HS of the Mineral Concession Rules. The following are inter alia the findings of the state government in the impugned order. Millard, I have given this page 324 to 354.
Yes.
Millard, it's a well-discussed order. Every aspect has been taken note of, unlike the previous order which came to be quashed by your lordships, the earlier division bench. Here, Millard, every aspect, the submissions, the representations, the contention, Millard, that have been discussed. It is not like the earlier order. 5521 is a composite and comprehensive order, which takes care. I was going through each of the orders, Millard, last night. That is different. So therefore, the contentions were same. Millard, the reasonings are bound to be same. It can't be different. Contention, they say the force measure. It can be differently worded. I fail to understand why they say that it is a stereotype order. If you say that corona is the cause, pandemic is the cause.
Reasoning applies when you make this submission that all the writ petitions are.
Your lordship is correct.
Grounds were same.
Secretary cannot have, Millard, devise a new dictionary to write better English.
All right.
He has to.
All right.
In pursuant to the direction of this Honorable High Court, the state government by virtue of letter dated so and so 24/5/21 notified under Rule 12(1) HS of the MCR 2016 granting 1 month to the petitioner. Let this notice 12(1) HS. Again 1 month was granted. Notwithstanding that 7 months, your lordship may kindly, again 1 month was granted because there was no barrier up to 31st September 2020. Sorry, 31st October 2020 initially. Again, they were given time up to 24/6/2021 for removal of this stuff. They didn't. They didn't. And by virtue of interim order, they were granted time till 15th of December 2021.
Yes.
Lord, in a equitable jurisdiction, I still ask my conscience, Lord, how is it possible? Asking for issuance of a mandamus in a 2, your lordship was absolutely right. That day submitting, it's not 142.
No, we see, we cannot issue direction under 226, like do this.
Right.
We will have to, if we are convinced, we may ask them to decide.
Right.
The decision which they are required to take,
Right.
we cannot take.
My lord.
We cannot substitute our opinion.
That is, Millard, rightly, therefore, the court didn't do that. In the earlier round of litigation, the division bench of Chief Justice Rafik and Justice Rath.
Prima facie, we are of the view, subject to what you submit and submissions are made, that the views expressed by the division bench on the issue of the effects of COVID-19 have not been duly appreciated by the secretary while passing the order. This is prima facie view. Maybe we change our
No, that's I'll
Prima
come to
facie,
that. I'll answer that.
Opinion.
Not any doubt, it is my bounden duty to clarify. If
Right, right. Your submission is very clear that by operation of HH, the property is
So
vested in the government, and that is the law against which the High Court should not issue a writ of mandamus. This is simple.
Absolutely.
This is what you are.
That is exactly, I'm deeply obliged.
This is what you are saying. Now, you have to make further submissions. Do you have to make?
Miller, I'll come to the decisions also.
No. Have you completed the list?
No, that chart is still, Miller, it is 2 pages.
Please.
Everything.
Please
There are only 2 pages left.
If there is something important, then refer to it. And
Yes.
then
25.6 million.
we need to see, so many things will depend on how do we interpret the statutory provisions.
Right.
All right.
Right.
And the 3 provisions, FF, GG and HH, are crucial for interpretation.
Right.
This way or that way.
Right.
Therefore, I indicated that whether FF can be read after GG and after HH also, or FF has to be read only before GG.
So that has been, none of this argument has been advanced in Chugle also during Corona. That I'll come to that.
No, see, whether the way we are dealing with HH and GG, they have been dealt with in any of the, you are referring to Karnataka, you are referring to earlier decision of this High Court.
So in Chugle 1, Chugle 2, they have discussed.
GG and HH.
Yes.
So this question again.
I read only 1 paragraph from that order. I'll come to the decisions little later. I'll come to the decisions. And the force measure clause, Milord, of the old form K has been discussed in this particular petitioner's case way back in 1969 by this Honorable Court. I'll come to that. It's a very important decision. This force measure clause. I'll come to that. In what situation and what would be in a contingency this would be applicable. I'll come to explain. It has been explained in 2 cases, in the Energy Watchdog and Sirajuddin of 1969 division, Justice Burman and Justice Acharya, S. Acharya. I'll come to that decision. I'll place it little. Decisions, Milord, I'll place tomorrow. I'm feeling little exhausted.
All right. You have water. You can have water if you want.
No, water is there. Milord, tomorrow I'll continue. At 2 p.m. It's already 4:05 also. If your lordship would, I can continue for another 10 minutes.
No. If you are exhausted, then why?
So exhausted means yesterday. So I had to.
I'll just.
Just let me finish this.
No, don't.
No, Milord, I'm okay. Huh?
All.
I'm okay. 24/6/21, 24/5, Milord. In pursuance to the direction of Honorable High Court, the state government, by virtue of letter number so notified under 12(1) HS of MCR 2016, granting 1 month to the petitioner to remove all balance materials lying in the leasehold area, which were authorizedly extracted prior to expiry of the validity of the lease, that is 31/3/2020. This was subject to the condition that the ex-lessee petitioner shall give an undertaking to the Director of Mines to the effect that he shall abide by the final outcome of the order passed by the Principal Secretary in line with the Honorable High Court's judgment dated 22/12/2020. Further, the said notice under 12(1) HS of MCR 2016, granting time of 1 month, would commence from date of submission of the said undertaking. Instead of complying with the notice dated 24/5/21, the petitioner, on completion of 1 month, by virtue of letter bearing number so dated, requested the authorities, but they conveniently waited till the expiry of 1 month. Didn't take any action. On 24/6, request the secretary, don't take any action. And exactly after expiry of 1 month, on 25/6/21, they come before your lordship and say that grant us again 6 months time. Look at the Milord intention. The intention of a party is very important in a 226 proceeding. How is playing Milord? With his clear abuse of your lordship's jurisdiction. Party is Milord, he is playing hide and stick with its public property. It's not Milord anybody's, it is your lordship's property, my property.
It's property.
It's not my property. It's
No,
not
what
the
is
property of state of
what is the
Odisha.
value? What is the value, total value?
5,000 crores.
5,000 crores.
Crores. Maybe more than that.
All right.
They were quantifying at 5,000 crores. I don't know what would be, Milord. It is a poor state. Your Lordship knows these are all tribal areas.
Oh, no, we have to take interest of the state also, because that is
Of
public
paramount
that is
consideration.
public interest.
That is public.
And at the same time, we cannot ignore individuals' rights.
So individual
So we-
rights,
we need
yes,
to-
Milord.
We need to balance. We need to
Nobody,
balance.
Milord, has prevented
And
the
we
individual.
don't need to balance. Rather, we are required to follow law. Whatever the law
Right,
says, we
right.
will follow.
Milord, that is the
So
ultimate
what-
thing.
See, but the process of adjudication, of course, is still on. And you are saying that the value of the ore is very high.
Very high.
Can you think of that you can take possession? The state government is your property. You can take possession of the entire thing. Just evaluate, how will you do that? If we permit you to remove the ores wherever they are, we will have to work out something to determine the value. And subject to decision, this will serve both the purpose. The ores shall be removed from the places, and that will be free for the new lessees to work. And then if they succeed, they will be getting their money. If you succeed, you will retain the money.
It's my money, Milord. It has vested in the state government.
Oh no, we are yet to decide. You retain that. We are not saying you.
The force of the state is empty, Milord. We have to work out we have so many commitments for the people. It's for the development of the state ultimately. They are, Milord.
Yeah, have we said that this is not your property? Have we said that this is your property? We have not said anything. We are just trying to understand that if, according to you, and all of the ores are lying, and for the new lessees, the ores are required to be removed. So if the ores are required to be removed, then can we develop a mechanism where you can remove according to you, the value is more than 5,000 or 5.
Maybe more than that. I was just
55,000
casually asking the
55,000
officers
crores.
what would be the value.
So you can keep that amount, and whoever succeeds, he'll be getting the amount. If the estate succeeds.
So that your Lordship may say that so that we can put it to auction.
So tomorrow we can think of on this line also.
That's correct.
All right.
Let it be, because it's lying, it is creating hindrance for the new lessees, number one. Number two,
That is also very
the new
important.
lessees also cannot fulfill their obligations under 4B and may be visited with
So
penalty.
therefore, just think of, you come out with a policy, you come out with a scheme where their rights are not negative. Their rights, these writ applications are pending since 2021. We don't know what will happen. What decision do we take? But in the meantime, why both of yours interests should suffer?
No, Milord, what I propose, respectfully subject to your Lordship's agreement, let the ores also, Milord, the quality of the ores also, Milord, it is degraded day by day. If it is exposed to sun and rain. No, your Lordship may kindly appreciate.
Yes.
Let the ores be sold, because let it be sold, put to auction by the state. Let the money be kept in an interest-bearing account.
General, just seek instructions. Seek instructions. This is just an idea. We don't know whether we shall pass such order or not. It's just that came in our mind.
Your Lordship is absolutely correct, Milord.
That will
It is to
help
be disposed of.
We will not dispose of the writ petition.
No, the minerals are to be disposed
Minerals
of.
should be
Dispose of, let it be hard. Milord, I don't have any.
This is in public interest.
Yes.
That the minerals should be removed, and thereafter we shall be determining
That's correct. That's
respective
correct.
rights of the.
I'll come out with a proposal tomorrow, Milord. Let me discuss with the government.
This is
I'll
one
come
thing.
out.
And the other thing is that we would like you to address again, reiterating that FF is a provision.
Right.
Whether FF is always to be read before GG, or FF can be read after GG and after HH.
I'll address on that. There is no decision, of course.
It is only because FF is above GG, therefore its stage will come.
Refers to the Milord clauses. So far, the terms
Just
and
examine,
conditions.
just examine, or all the three are to be read together. FF, GG, and
That would be an extreme scenario, Milord.
No, that is not extreme scenario. That is not an extreme scenario. When we read any provision of law, we read the entire law. Like section 1, section 2 is very important. Section 2 is important. Section 1 is also important.
Right.
So we have a holistic view of the entire statutory provision. Similarly, in this case, please examine whether we have to read FF, GG, and HH together, or FF after HH or with HH, FF will have no application. So just examine.
Right.
Anyone for the petitioner? What is the if we this matter has remained pending for about 3 years. So in the meantime, your quality has deteriorated, he is saying, and it may deteriorate further. So can we think of that in the meanwhile, that will be in the larger interest of every party, that in the meanwhile they may dispose it off, and you will be entitled to.
Well, that's my humble submission is that let the government come out with a proposal, and whatever, depending on what the proposal is, we will
let him first seek instructions, come with proposal, and then we will see. What can be. Then we can comfortably decide this matter.
Right.
Otherwise, we have also a feeling.
The case
that
relied, one of the case relied, the Midwest case, the same proposition came. And Honorable Apex Court decided that it is the petitioner to sell the product. And
we will see. We will see.
That way
we will see. We will see. It is that will amount to
I don't think
us deciding the case right now.
The state also sells it and puts it to auction. Not sale, it is to be put to auction. No, that is to be put to auction, Milord.
Deposit in the court, and the matter would be.
No, how can they sell it? Yeah. No, I'm not getting disturbed, Milord, at all. They say we will sell it.
We are just thinking of.
This sale is possible only when the royalty is paid, and extension is there, transportation, everything is done. Then only the material comes to. But the state,
you will have to arrange transportation.
Everything.
You will have to arrange so many things.
Everything.
And if the estate does that, if the estate does that, and if the amount, the entire amount is set aside for this case to be finally decided, then what problem can you have?
The question is, my lord, there is an IBM price prescribed. That's the minimum. And in the market, the market price may be more. And in that case, we'll be going according to the grade that is given. But supposing the state would be given, the grade fluctuation would be there. That we know. So which stack is having which grade? Because in my case, the petition number 2's case, there are high grade materials also. Out of the total. And there is fines also.
All right.
So all together would be different categories.
All right, we will decide your case. If let him come with a proposal. If you don't agree, it is not that we shall be forcing anything upon all of you.
I'm saying reasonability.
In that case, so as specifically file a counter by the IBM and clarifying all the position.
And as IBM fixed the rate, because I remember Ghanshyam Mishra, the case was that IBM was not fixing the rate and they were being pressed by the petitioner that you fix the rate, then we can dispose of. I don't know if that has been done or not.
Normally, IBM notifies a particular price.
No, in one case they had not notified, so the petitioner was facing difficulty in disposing of the.
Thereafter, we have rectified the same and fixed up the price.
All right.
As per rules, if there is no IBM price for a particular month, then 6 months last period can be taken.
Last
year. So you work it out, please.
No, that was clarified with the IBM.
I just remembered
so that
if I asked.
We can think of on that end also, because why at all the mining activities
of these subsequent lessee should stop.
Oh, that is not affected. In my case, my lord, the subsequent lessee, that is the JSW, in fact, the 4 years time from 20 to 24, they have achieved the target given by the state. I have got the statistics. More than the statistics that is given. Supposing is given 7,000 or 7 million, 7 million they have achieved.
We will see.
So that is there.
We'll see.
That there is no loss to the
We will see what
new
can-
lessee so far the
We
operation
will
is
see
concerned.
what can be done.
Six petitioners are there. So the council from, learned council from all the six petitioners will have to.
We will see, we
Yes.
understand.
May not be that easy, let
We
it
are
just come.
talking about the date tomorrow, whether it will be practical for them to get the government's policy.
No, even otherwise, he will continue his arguments. So, either way.
Yes,
Because we have to answer a little.
They decide for me what I should do, what proposal, whether
No.
it will not.
They're-
They know what is.
They are anticipating. Like you.
Before my response to your lordship's query, they decide what is to be done by the.
Let us see what. Michelle,
So tomorrow.
can we take up any matter urgent? Just
Tomorrow.
Yes, tomorrow.
Tomorrow 2 p.m.
2 p.m.
Like.
Lordship's permission. May I prayer?
Yes, where is your matter?
Hear your matter now.
30.
Yes.
So who is there for the other side?
Other side, that is the problem.
Who's for the other side?
Mr. Kanungo, Milan Kanungo. Try tomorrow. Try tomorrow.
Can it be faster?
Please make a mention. Today we are ready.
Yes, this matter is posted tomorrow again.
Tomorrow.
My date will be similar. Day after tomorrow, probably there will be.
Let us see. Try.
Tomorrow, matter.
No one's fate is sealed.
Pardon me.
No one's fate is sealed. Once he has come to the court has duty to.
Interim order, that I have.
Interim order
It's
no,
not
that-
executed exactly, but some
Clarified.
technical my lord knows that
Clarified.
everything where somebody not written it. Only that is my predicament, my lord. Can tomorrow. First of all, for this purpose.
Tomorrow make a mention in the morning.
With your lordship's permission, if I may mention, item 83, your lordships on all your occasions had directed this matter to come in the top 5 cases. Because this is relating to the admission in the diploma course in industrial safety. Your lordships directed me to file an affidavit including the photographs and everything.
30 plus 30.
Yes. So I have done that. It's so if your lordships will take it up tomorrow,
Make a mention in the morning, we will see.
please.
Millard, item 48, can it be taken up
Okay.
tomorrow?
Sir,
Item 48, Millard, in today's list.
what is the urgency?
Urgency, Millard, the state is going to appoint the teachers. We are at the same, that is the challenging that order of reservation
You can wait.
policy.
You can wait.
Well, it's item 54 in your lordship's list today, my lords. It's a tender matter. There is a work order which has been issued pursuant to your lordship's being seized of the matter. And 6
You can
months have
file-
already lapsed.
Your rights can
If it can come tomorrow.
not tomorrow.